Yes, please.
Item 81.
Because I had filed and mentioning my lord with respect to filing is the matter on
Is it listed? Not to be deleted.
my lord, what is the difficulty I have faced is that my lord, I have moved an IA indicating the stay of the order dated passed by this court on 5th of
What is the, how does it affect you?
my lord, what is happening is that the strangers are creating third party rights. They are filing frivolous suits, my lord, against the suit property, my lord.
Frivolous?
Suits they are filing, civil suits are filing
Thank you.
for injunction, my
Not
lord.
to be deleted.
May I seek your lordship indulgence?
It's kindly be listed on Monday, my lord. Or
Thank you. Thank you.
Friday, my lord.
Thank you.
May I seek your lordship indulgence?
They told you 19th of August not to be deleted, sir.
And the 13th of August it is.
Whatever date is there, not to be deleted.
Lord, I seek your lordship indulgence, my lord, to make a mention. Day before yesterday, my lord.
No. Is it, we'll just wait the listing, listed mention.
After that.
Item 802.
Lord, the matter is listed for 14.8. Lord, the only plate is not to be deleted.
Not to be deleted.
Item 803.
In fact, I will tell you, as far as this court is concerned, we have umpteen number of times told the registrar general, registrar list, that no matter before this court should be deleted. You can give us n number of matters, it doesn't matter to us. Still, what do we do? It's not in our hand.
Yes, sir.
Item 803.
I am the respondent husband in the wife's transfer petition. Lord, your lordship stay order has been misinterpreted that the interim order for
Whatever it is,
custody.
what is the date?
The interim order for custody has been because
What is the date?
11th August. Can it be listed earlier?
Thank you.
Not to be deleted. That's the humble request.
Not to be deleted.
Most of it.
And you may remind the registrar judicial that as far as this court is concerned, why does he delete? Unless, of course, Honorable CJI may.
Sorry, leave it at that.
No, you may tell him, please. What do we do?
Most of it.
Causes inconvenience to you and to us both. Yes.
Lord, day before yesterday, my lord, one service.
Some correction.
Lordship passed the order dismissing the lord's SLP, but permitted me to withdraw. But lordship had also granted me liberty to go to the High Court. Inadvertently, my lord, this is missing out.
Just 1 minute.
This was, my lord, seniority issue and the reversion order.
1 minute, 1 minute, sir. ये फाइल के साथ put up it. Put up it.
I'm grateful.
Your lordship may mention in a matter where stations and
They were not party to it.
You were not party to some of the petitioners. Were party, some of
my lord, out of
some of the
42,
petitioners were not party.
2 were petitioners, my lord, 40 were not petitioners. Grateful.
your lordship may mention in a matter wherein suspension sentence has been allowed by your lordship and the criminal appeal is pending before the High Court. But in this order, a criminal appeal is pending before this court inadvertently written in the order. On the first page, criminal appeal written in the
Vikramnath की कोर्ट के वहाँ है नहीं तो उसके आप क्या ही mention
नहीं, Honorable Justice Vikramnath is not there.
Yes.
But is Honorable Justice Nandi Mehta साहब तो है ना? Regular bench को ये make a mention before. See, I have been sitting in a 3-judge bench combination.
yes, your lordship.
Now the regular bench is Honorable Justice Nath and Honorable Justice Mehta. It would be only prudent that you please go there and make a mention.
Yes.
Should you wish to make it?
Organization.
By 3-judge bench or 2-judge?
3 judges. 3 judges.
You are the next senior.
तो सीनियर तो हमने
You are the next. Correct. But no regular DP available. नाथ साहब का और नाथ साहब का और correct.
Your lordship, actually matter is listed before the court today itself.
Why don't you go and make a mention before Honorable Justice?
Yes.
Go and make a mention. If nothing happens, come back to us. If
Then,
nothing happens, come back to us.
organization.
Item 1.
But make a mention. You may inform the Honorable Judge that you have made a mention here. And because now there is a regular DP of Honorable Justice Nath and the Honorable Judge available, I mean, That's the combination now. So therefore, prudently we thought it, you to mention there.
There is a pre-dated French order.
Yeah, there, okay.
Yes,
You go there.
yes, yes,
If nothing happens, then you come back and make a mention. Huh?
yes, yes.
Please, Your Lordship.
One lordship has asked respondent to file affidavit stating that regarding that LinkedIn profile, and I have been asked to file rejoinder. I have filed rejoinder in detail, showing that at the time of filing of this petition, I was in Kolhapur. Thereafter, for 2 months, to September to November, I went and got a job to show that I went to Bangalore. Then again,
You're in Kolhapur, that's why.
again Kolhapur, everything has
My lord, there is something I have to say, my lord. During September, even as per their own affidavit, from September 24 to November 24, she was in Bangalore. Now,
You're to Kolhapur now it's all.
my lord, she is in full-time work now in a company based out of Hyderabad as per their own document, my lord. The last document which they have annexed.
she is working work from home.
My lord, I will be permitted to appear through VC, my lord.
That
Always,
is
Lordship.
always
Right.
there, subject to the availability and the further orders passed by the
Right.
That is always there.
Please, my lords. My lord, this is a transfer petition filed by the wife.
As per, the office board service is complete. Transfer. No? Yes, what is there? Mediation report there? Just possible.
Well, this is a transfer petition filed by the wife. Settlement has been failed, Your Lordship, and we are seeking transfer from Pune, Maharashtra to Betia, Bihar, directly in
Your Lordship, if I may only suggest, Your Lordships may keep it in Pune. I am ready to pay for boarding and lodging and everything. Then, my Lordships, Your Lordships may please allow me to appear through VC.
That is part of the order. We always say.
I'm so very deeply. I'm so very
Subject to availability and the convenience.
I'm so very deeply.
Other direction by the
I'm so very deeply.
deeply.
Your Lordship, here for the respondents, we've just been informed by the client. We've not filed the Vakalatnama.
Just 1 minute. This is 1 minute. Yes, it's a. Can't use it.
May it please, Your Lordships. Your Lordships, I'm seeking transfer of this defamation
Who are you?
complaint. Your Lordships, I am the accused in the defamation complaint.
See, defamation, it is not, Arnab Goswami would not apply here, no? It's a
Yeah.
private complaint, no?
Your Lordships,
There is no defamation in a private communication.
I understand
That principle would not apply.
Your Lordships, I am carrying a matter in which this Honourable Court has allowed transfer on a defamation complaint in a prior matter. If I may kindly hand that across. Your Lordships, the same complainant has also filed a private complaint against me in Calcutta.
That is on a completely
1
different.
minute, gentlemen,
I'm sorry.
she's a young counsel at the bar.
I'm
only seeing what she's.
Your Lordship, on a lighter note, I'm grade early, I'm also young, just on a very lighter note.
But not younger than her.
I was just pulling it.
Nothing is mentioned here.
Your Lordships, this is a defamation complaint that would file.
Maybe, but not, it is not mentioned in the order.
Your Lordships, if Your Lordships will give me time, I will file the trial court order in this matter as well. This is not my matter, but Your Lordship, this is
My apologies, you are working with whom, ma'am?
Your Lordships,
Are you independent now or are you working?
Yes, Your Lordships.
Is it a judgment?
Your Lordships, this is the order of this court
Thank you.
allowing a transfer in a defamation complaint.
You've seen that. We are not allowed
Your Lordships,
to argue anything further.
Your Lordships, that the same respondent herein has filed a private complaint in Calcutta against me. The private complaint has exactly the same allegations. He, however, claims in the private complaint that the criminality made out is emotional hurt caused to him, and he has mentioned section 323 IPC in that private complaint. I have annexed that as P1 of my transfer petition. The exact same emotional hurt or reputational damage is now being sought to be agitated once again in a separate private complaint in a totally different state. Your Lordship, I am unemployed. I was thrown out of employment because I was a whistleblower in an insurance company. The respondent was the CEO in the company at that time. Within a few months of me raising issues about non-compliance in that company, I was thrown out. Thereafter, an FIR was filed against me in Bombay. I was arrested in that FIR, kept in for 2 months. Criminal defamation in the Bombay High Court with a prayer for 100 crores as damages. Thereafter, private complaint in Calcutta under 323 for emotional.
There are only 2 grounds which you have said in your SLP. What you are saying here is none of the grounds. Thank you.
Your Lordships, I've set all of this out in the grounds. I've also filed an application for additional grounds. Your Lordships.
We are not in
Your Lordships, may I then only request permission to appear on VC before the Honourable Trial Court?
That you make a request. Likhika. What's your good name?
Rupali.
Your Lordship, I just like to interrupt here. My instructions are a bailable warrant has been issued because of non-appearance. I'm sorry, sir. Your Lordship
You should know how to.
I told I have applied. I'm
sorry, now you file a counter. Within 2 weeks, you joined over.
Lordship, may I request for 3 weeks because the client is not.
No problem. 3 weeks.
Your Lordship,
State.
Item 6.
It is not out of anger that we are going.
I understand, Your Lordship. It is my mistake. What happened was
200%. We must know the younger people there.
My apologies for it. She's a good friend of mine also.
We all learn from each other every day.
Okay. Your Lordship, why I was mentioning is on the VC thing, these.
Thank you, gentlemen.
Item 6.
Pass it.
Please, Lord, I am appealing for petitioner husband.
The possibility of settlement.
Yes, sir. I'm with the state. The complainant is not made the part.
Complainant?
Lord, as per office report, respondent number 2 complaint has not been served.
So no.
Lord, may I have it after a week? We will file this particular during course of the day.
Respondent number, private respondent number 2 remains unserved. As per office report.
Yes.
Let steps complete in all respect by furnishing better particular, latest and better particulars be put it under.
What's the period?
Item 8.
May please, my lords, this is a challenge to the rejection of an anticipatory bail.
Why was it rejected?
Only on the basis of call detail records, my lords. The learned High Court has come to
What were you indulging in?
My lords, the Honourable High Court has come to a.
What were you indulging in? Allegedly indulging in.
No, my lords, my case is that the persons against whom they are.
Allegedly indulging in. We are only asking for the allegation against you.
There is no allegation against me in the FIR. I have not been named.
You're right. Not named in the FIR.
Right.
But as per the status report, your name surfaced during investigation.
My lords, it is
and you are absconding. That's what it is.
My lords, may I just clarify that? My lords, status report only makes a disclosure that allegedly one of the 2 accused has named me. However, that alone. Does not make me or implicate me in the case, my lords. There is a judgment of this honourable court which says that in the absence of any other evidence, a mere disclosure is not sufficient to.
Call detail show your presence there.
But it is not the presence. Call detail records, my lords. Only show the network from which I am connected, not that I am present at the back.
That is how the record reveals. We are not saying it is right or wrong.
No,
it's not a case of A-bail.
My lords, the scope. May I just make one submission then, my lords?
Yes.
My lords, how and why I am being implicated is because the prime accused, MISHRA, was the one who came to me on the night of the incident at midnight, asked me to write a complaint. I am a final year LLB student.
We've seen that.
Right.
And,
So
and that is precisely what we were discussing. A law student has all the more reason to abide by the law.
Well, he only drafted a complaint reporting this illegal. May I just take 1 more minute, Malad? Malad, may I just take 1 more minute? There is another aspect to this. Malad, Thakur Stone Crushers, who has filed this complaint, is the one against whom NGT has taken cognizance that they are engaging in illegal mining. The menace of illegal sand mining on this very Swan River is not something which has escaped the rest of law.
Only, ma'am, because you are a law student, you are issuing notice, but with the understanding that please don't assure your client what is going to be the final outcome. Okay?
Malad, may kindly protect him. I am obliged. Yes. Deeply obliged.
Item 9.
Please, my lord.
One minute. Notice.
My request to make is returnable within 2 weeks.
We always give a date, sir. In addition, sanction.
May I request for an interim relief?
No.
Grateful. Behold.
These millets are begged to pay for the petitioner in this matter. Millets against the same impugned order, same FIR millets notice has. We requested just kindly tag this SLP with SLP criminal number.
Okay, tag along as great.
And standard consonants.
Notice for then legal order, then tag.
Item 11.
Your Lordship, the petitioner is the former general manager of the complaint company. As many as 4 complaints were lodged against him by the company. 3 were registered. In 2 has been released on anticipatory bail. The
There can't be a reason to continue to release you on anticipatory.
The day on which the second was granted, on the next day he filed another. And this time he has come up with a allegation that I was involved in an offence which was a threat to the national security.
Correct, because you see, if you steal data and information.
But these allegations were already there in the earlier complaint. The second complaint is not even, second FIR is not even tenable, Your Lordship. Because what has happened, Your Lordship, this honorable court in Anthony's case.
National security is involved. So
but national security, how national security is involved, Your Lordship? You have to see it.
How you answer during trial?
No, why during trial? He says I am a terrorist. Your Lordship will believe it.
Yes.
There must be something.
Yes, at this stage we will believe. Yes, next.
Kindly see, Your Lordship.
Yes, we have seen.
These allegations cannot be.
We have seen, sir.
Article made, sir. The item 11, sir. I'm the party person.
Item 12.
Yes, sir. I did
11,
sorry. 11.
Matter is over.
I didn't do that anything, sir.
Matter is over.
I respect, sir, but this is
Matter is over, sir. You have engaged a counsel, a senior counsel at that. We have heard the senior counsel. We have read the file, and we do not agree with the submissions made, or rather, we are not persuaded. So therefore, we have dismissed. Thank you.
Item 12.
Out of 10, my lord, 7 have been lodged on bail. And because he happens to be the entire story based on circumstantial evidence.
You are the ठेकेदार, actually.
Because he happened to be contractor and from Pratyush,
wait for some time.
71 witnesses are there, my lord.
You
sealed the dead body.
You dug out a page.
Pratyush Pandey on behest on behest of Pratyush Pandey, my lord.
Then cemented it.
Then I
constructed a
on behest
water tank there.
Water tank.
Pratyush Pandey, my lord, on behest of Pratyush Pandey, dead body was recovered. He happened to be contractor, my lord.
The allegations are.
Yes, he
very, very serious against you.
Then I withdraw with liberty to repeat after some time.
Seek permission to withdraw the present petition
At this
at this stage, with liberty to file a petition should the trial not progress.
Please, Your Lordship, this is regular bail under NDPS Act. The applicant is in jail from 7th of May 2023, but the charge is yet not framed. We have raised this issue before the High Court and the High Court has not considered it. There is another point that the co-accused is released, Your Lordship. That order is at page number 45. It is more than 2 years, Your Lordship. Please, Your Lordship.
In the response itself, the respondent shall furnish information with regard to the framing of charge, stroke trial, progress of trial.
Please, I'm grateful. Number 2 is NCB, Your Lordship. Therefore,
notice will go to both.
Please. I'm grateful.
Please, my lords. Lords, for the same offence, my lord, 6 FIRs are registered, my lord, in the same police station, my lord, against the same company, my lord, within a span of 3 months, my lord. Kindly have a look at page 4, my lords. The first case, my lord, is registered on 1st of January 2022, that is after more than 4 years, my lord, of the alleged commission of offence, my lord. Second is, my lord, FIR number 45 in the same police station, my lord, on 1st of February 2022, my lord. Third, my lord, which has already been quashed, my lord, by the High Court, my lord.
No, but if you keep on,
My lord, the thing is, my lord, all these FIRs, my lord, the same offence is there, my lord, between the same companies, my lord.
There will not be same cause of action, na? You continue to cheat different people.
My lord, the offence is in 2018, my lord, it was committed in 2018, my lord. FIRs were lodged in 2022, my lord. Out of these FIRs, my lord, 2 have already been quashed, my lord. Rest of the 3 matters, my lord, the notice was issued by the Honorable High Court, my lord. They are pending for 12th of August, my lord. I'm sorry.
Where not on merits on the basis of compromise.
Yes, my lord.
Yes.
But my lord, I am neither the partner, my lord, nor the director in any of the companies, my lord.
I will tell you.
Yes.
You are saying 2018 and 2022.
Yes, my lord.
Finally come to page 27.
Yes, my lord.
The delay has been explained.
That's true, my lord.
You would be
for the same offence, my lord. For the same offence, my lord. Same companies, my lord. In the same police station, my lord. Then, my lord, if my pray, my lord, if the matter could be sent for mediation, my lord, I'll try to sort it out, my lord. Then delay may kindly be condoned, my lord. Delay may kindly be condoned.
Not a matrimonial dispute, na?
Delay may kindly be condoned, my lord.
Delay.
Thank you so much. Oblige me.
Lordship, I'm seeking a short pass.
I will pass it.
My lord, seeking a short accommodation in this matter.
It will not be taken up.
All right. I'll just go that side.
What do you want?
You are seeking accommodation for what?
For the senior advocate is on his legs in another court, so for next week, my lords, I was thinking.
Lordship, I would after 2 weeks, we will also have to file a GO copy. We will not.
We do whatever you wish to, sir. No problem.
Oblige.
2 weeks are there. Okay. 2 weeks are jointly paid. 2 weeks.
Item 17.
These, my lords.
Okay.
The 17th.
My lords, I'm seeking anticipatory bail on behalf of the petitioner, my lords. My lords, I have only been I have been denied anticipatory bail because I have been named in the disclosure statement. That's it. I have not been named in the FIR, and in the disclosure statement, this whole case is about narcotics. I am not on narcotics at all. All that is said about me is that the gun was given to me 2 months before the FIR was registered by the main accused. That's it. Nothing else, my lords.
You're part of the gang.
My lords, I'm not part of the gang.
This is the allegation against you, and plus 2 antecedents against you.
My lords, the allegation is the same.
1 minute. The High Court record that there are 2 other cases against you.
Please, my lords.
Now, how have you dealt with it in your grounds of appeal or synopsis?
My lords, I have said that I am on bail in those 2 offences.
What is the nature of those offences?
My lords, one is an Arms Act offence and one is an attempt to murder offence. I understand, my lords, I've dealt with it.
Thank you.
I'm on bail.
Thank you.
But my lords, a judgment of this honourable court itself, but just my lords may bear with me 30 seconds if my lords will bear.
1 minute.
I understand, my lords.
30 minutes, no problem. But look, what is the allegation? 4.5 kg of heroin coming from across the border, and gun is given to you, and you are part of, pistol is given to you, and you are part of this whole racket which is being run of cross-border, trans-border,
My lord, I understand.
and you have a history.
Yes, my lords. History is a problem. Yes, my lord. However, my lords, in NDPS cases, this honourable court has granted anticipatory bail.
We do it day and day.
I know. I know it's because of antecedents, my lords, are not declined. Grateful, my lords.
Item 18, I appear in, my lords. May I be permitted to commence? While suspending the sentence, the High Court imposed a condition that the entire check amount has to be deposited. Having read the erudite judgment of Justice Mishra, I am on a limited prayer, my lords.
Continue.
My Lord Justice Mishra has held, interpreting section 148 of the NI Act, that there is a discretion vested with the court whether to direct imposition or not.
In that Jambori matter.
Jambori matter, but in Muskan Enterprises, my Lord has interpreted.
Muskan matter. Muskan
Enterprises, my lords. The discretion not to order is in exceptional circumstances. Number 1, my lords, I plead an exceptional circumstance that appeal could not have lied before the Court of Sessions at all. In view of Mallikarjun Kodagali, as per 378(4), it has to be only an appeal before the High Court. My lords made an interpretation. Direction was for him to surrender.
Subject to.
You have to deposit some amount.
In that case, my lords, as per 148, my lords have held that once the court decides to exercise its discretion, it shall not be less than 20%. My lords may have it.
Yes, we know that is the statute.
20%, my lords.
You deposit.
20%.
So that we will not send it back to the High Court again and decide it here itself. If you deposit,
my lords may grant the permission to deposit
50%. You deposit 50%.
My lords, 50% may be too much.
Not to worry, only 14 lakhs.
My lords may have
14 lakhs and 50% is 7 lakhs.
My lords may kindly have it at 20%, the bare minimum amount. If the revision is dismissed, he anyway has to go to prison to pay the amount.
Yes.
Only as a temporary measure, his daughter is about to be married. Lords. My lords may fix it. I find it embarrassing to state this, but it may be 3 lakhs.
5 lakhs. Deposit 5 lakhs.
63-year-old.
5 lakhs, that is
it. To the petitioner depositing some of these 5 lakhs in the registry of this fraud.
Humbly beseech my lords, 53 lakhs. I find it very embarrassing to say this.
On bargain with the court. Be modest.
May we be granted 8 weeks time limits?
Within a period of 4 weeks. 4 weeks. 4 weeks. Auto renewal. It's notice.
I'm going to pay for that.
It's 19, my lords. In fact, the interim judgment. The Bihar State Financial Corporation came in appeal, my lords. My lordship, please to issue no.
Lord, I appear on behalf of respondent number 9. Respondent number 4, my lord.
Yes, Mr. Singh. How are you?
Fine, sir.
Are you intending to assail this order or no?
My lord, I am respondent hearing. Item
You know
number
that.
19.
You know that. Anyhow,
I am supporting the judgment.
your respondent number?
4.
You are the plaintiff.
You are the plaintiff.
I am plaintiff here.
Plaintiff and I am the option purchaser, my lord.
He's option purchase.
I am the option.
He's not the plaintiff. He's the plaintiff. This is one number 4.
Whereas he filed the suit.
Okay, okay.
Yes, my lord. He filed a suit actually asking for setting aside of the auction sale. And that was partly allowed.
It has already been stated.
Yes, my lord. State already stayed, my lord. First in September is the
State Financial Corporation appeal, my lord, was kind enough to stay the.
Correct.
There is 20 days delay in refiling.
Delay for no.
If my lord will please to tag both the cases together.
Sir, what we are doing is we are tagging it. You are accepting notice. Notice will go to the others, and we are tagging it. And that order which was passed in the first appeal, that very order would be passed in this.
Oblige.
Oblige.
Anyone in today?
Milord, may I please mention item number 2? Sorry, item number 3.
Yes. Mediation is in progress?
Yes, Milord. Mediation is still in progress. It is next listed on 22nd August.
22nd mediation is in progress.
Ask for 6. So I'm hearing for the petitioner. Your Lordship,
Notice, with a notice, sir?
the respondents entered the appearance, but reply has not yet been filed. If they will.
Counter is not filed. Where is the?
Yes. After opposite for respondent stands served.
There is a very.
None allowed.
We are allowed the transfer petition because the other party is not appealing.
Grateful.
Ask for 16.
16.
You were not expecting that it will be allowed. You were not expecting that it will be allowed.
No, Mr. Simple, not for you.
Not for you, then lady.
Learned Standing Council has
You
logged.
were not expecting that it will be allowed. Not to her. Yes, yes.
20.
Yeah, Panna, join.
Item 15.
Item 15 is you there?
Yes, my lords, I'm there, my lords. My lords, on the last date, my lords had asked us to get instructions on as to whether the Gujarat Civil Service Tribunal was in existence at that time, my lords, during the relevant period.
Correct.
I have examined it, my lords. The Act specifically excludes the policeman, my lords, from its purview.
So was it
Section
functional?
2.
Was it functional?
It may have been, but
Exclude the police.
the act
My lords,
excludes the police
the
force.
Act excludes, my lords.
There are very outside the building, some of the.
I'm copying, my junior is there, my lords. My colleague is there. She's carrying the copy of the Act. Section 2(1)(h), my lords, specifically excludes the policeman from its purview, my lords.
Then what is there in the matter, ma'am?
No, I'm for the petitioner, my lords. May I argue my case on merits, my lords?
Dispensation of the inquiry which has been done.
You are for the respondent or?
I'm for the respondent, but
I'm appearing for the state, my lords.
Okay, we will not take up this matter today.
Very
He
well.
is passing it over.
Lords may then have it tomorrow or next week.
We are telling you, Ms. Swati, that if there was no jurisdictional error, then we are afraid we will not interfere.
Malads, I will persuade Malads. This is a case, Malads. In fact, he was
throughout it's a case of he's just a constable only, na?
Malads, 18 cases. I will be able to persuade Malads. We keep it, pass it over Malads, or keep it tomorrow, Malads. I'll be able to persuade.
We'll give you time.
Very well, Malads.
May I have it tomorrow 20? Please.
Why are you?
Please.
The court is with you.
It's just that there may be a clash for me. I'll try to be here.
No problem, don't worry.
I'm obliged.
But it excludes police officers. This 2-1H.
It excludes, my lord. It does.
Police officers.
Police officers.
A constable is a police officer. How the word officer? Police officer is defined.
So,
Whether a constable is an officer.
please, my lord.
Be ready.
I will. Please, I'm okay. Item 20.
Officer.
Okay.
Please, Your Lordships. Lord, Your Lordship has had the benefit of hearing the submissions of my learned friends, Mr. Divan, Mr. Sibbal, and Mr. Ren. Lord, may I just map out what is the case and what is the submission which I propose to urge for Your Lordship's consideration? Lord, this matter began in the year 2016, which was by filing an application before the State Administrative Tribunal. Lord, the first time it was considered was 16th of February 2017, when Lord, the application was dismissed. Against that, Lord, we filed a writ petition before the High Court. The writ petition, Lord, came up before a division bench. The division bench, Lord, looked into the matter, came to a conclusion that because of the rules as they are framed and the notifications issued by the state of West Bengal, there arose a legally enforceable right. But the extent to which that right must be given effect to was a matter which the tribunal should apply its mind. It held in our favor that there was a legally enforceable right, but it needed, therefore, fresh consideration by the tribunal. Well, that judgment is important because many of the submissions which were urged yesterday were in fact urged in that proceeding, and my lord, those petitions came to be allowed. That judgment, my lord, of the division bench of the Calcutta High Court is of the 31st of August 2018.
Page 368.
That's right, my lord. That same judgment. That judgment, my lord, was sought to be reviewed by the state. That review also, my lord, came to be dismissed.
Page 444.
That's right, my lord. Then afterwards, we now come to the application coming back to the tribunal, and the tribunal, my lord, has allowed the original application. My lord, the various paragraphs which were read, it was suggested that the tribunal had simply overstepped its jurisdiction and had issued some sort of a mandamus, and to borrow the words of Mr. Divan, something alien to the rules was attempted by the tribunal. It was extraneous, to borrow his expression, to the rules and the notifications. Then, my lord, the matter naturally goes to the division bench once again. My lord, there are two judgments of learned judges. Both these judgments, my lord, have found four conclusions. The first conclusion is on the question of dearness allowance being claimable as a legally enforceable right has been held by the previous division bench, and the matter has acquired finality. That's the first. The second conclusion is that we read the rules the rules as they are framed clearly suggest that in order to adjust against the cost of inflation, the rule is indeed indicative of the fact that dearness allowance would be payable upon revision from time to time. Well, the concurring judge, in fact, very elaborately traces this entire AICPI, IW, for right from the time it evolved in 1944. Well, it's quite useful as a historical account. But then, what is important is that the learned judge comes to the conclusion that on an interpretation of the rule, both on its own terms and as understood by the government in its notification, this was meant to operate as a time-to-time benefit which had to be given because the very purpose of dearness allowance is to protect the real value of money. Well, if one understands this aspect, that dearness allowance is really to protect the true purchasing power which your wages or your salaries are meant to achieve. And keeping in mind the revisions which take place, there is an adjustment, and that is not something which is a matter of bounty, nor is it, a matter of, if I may say so, a claimable right per se. But if, the rules give this as a part of your emoluments, based upon an acceptance of the recommendations of the Pay Commission, then, I submit, that becomes a compellable obligation. So, the right to get existing emoluments reckoned in accordance with the rules is a legal right vested in me by the rules and imposes what we call in jurisprudence a corresponding obligation or a duty on the state to abide by that rule. And that rule, therefore, can legitimately be the subject of a mandamus. Because a mandamus always is in the context of a public duty or a statutory duty or a constitutional duty. Here it is a case of a statutory duty which is enjoined by the rule. Now, may I straight away take your lordships to the first division bench judgment and only 2 or 3 paras to satisfy you that that judgment, analyzed these defenses. This very same judgment of 1954 Supreme Court, which was cited by Mr. Divan yesterday, that is the state of Madhya Pradesh judgment, was also examined, and the court distinguished it on the ground that the words of Fundamental Rule 44, which was being interpreted by Justice Venkatramaya in that judgment, provided for the word may. And because there was the word may, this was a discretion which was vested in the government. So, my lord, this is one aspect. The court also dealt with other judgments and said that the law is, if there is a pay commission, it is not binding on the state government. The state government may accept it, may not accept it, may accept it in part, may accept it in total. Now, my lord, the court, however, says that if it is accepted and is translated into a rule, then that rule imposes an obligation. So then the rule, a rule could also permit discretion. Now the question is, my learned friends in their interpretation want to invest this rule with having induced a point A, after which, my lord, there is only a remnant of discretion. And that construction, my lord, is the one which I seek to displace in my submission for your lordship's kind consideration. Because this is, my lord, really the scope of contest. Now, my lord, I will also place those paras of the administrative tribunal. My lord, they were placed, they were rendered, my lord, in a context. The context was that, my lord, the central government was making it a practice to give dearness allowance when necessary, twice a year, because not twice a year you have the benefit of the discovery of the index. This word average, which your lordships find, is really, my lord, an average of 12 months, which is actually the basis of arriving at that figure 536 in the year 2005. So that is why you have the word average index, because it's over a period, weighted average, my lord, for 12 months. Now, having said that, my lord, let me take you straight away first to the rule and also explain, my lord, that it is time to time, because that is the purpose of the rule. So may I straight away do that, so that we deal with the heart of the matter.
We want to request.
Please, certainly, my lord.
We are conscious of this fact that we were conscious that you're going to argue that the division bench has already settled the issue and they have not filed any appeal, so therefore adjudicate our reply. You are aware of that. Now, we would request you for one thing, because it is going to have pan-India implications. You please proceed as though we are hearing it for the first time.
Certainly.
Because we have to lay down.
Certainly, my lord. Certainly. There's no difficulty at all.
That's how we leave it.
No difficulty at all.
Mr. Devan,
yes.
Yes. They were focusing only on the rule.
Yes.
So therefore, how do we read the rule?
Yes.
To your benefit and advantage is what we want you to address.
Certainly, my lord.
First, and then we'll.
Yes, certainly. Certainly.
The
certainly. And my lord, even if it is pan-India, I'm not, if I may say so with respect, I'm not overwhelmed by it, because even consistent with all the judgments which I'll place, my lord, it is very clear that the law is that dearness allowance is an integral part of remuneration. Secondly, it is vital because the real value of money must be available to an employee of the government. The third is, if it is left to the determination of a pay commission, and the pay commission makes a recommendation, it is open to the respective state government to either accept it or reject it. It is not binding, proprio vigore, although there are judgments which say it is entitled to some weight because it is an expert body, but we will leave it at that. But if it is accepted, then it binds the state government, and if it is, my lord, then metamorphosed into a rule under Article 309, then the rule, my lord, becomes a compelling obligation. So this, my lord, is the. Now, my lord, may I straight away take your lordships to the rules?
Please.
And before that, my lord, if I may invite your lordship's kind attention just to see the context of the rules, which is, my lord, please see Annexure P1, which is at page 97. It is a part of the Pay Commission's report produced by the state. That will be printed page 97, my lord.
Chapter 10.
Yes, chapter 10. And PDF would be 137. This chapter 10, my Lord Justice Mishra has said. In this chapter, we have discussed 4 of the most important allowances now available to the state government employees and also to some of the non-government employees covered by our terms of reference, namely dearness allowance, medical allowance, house rent allowance, and non-practicing allowance. We have not been able to devote our attention to other allowances, including the so-called special allowances that the state government currently pays to its employees, some of its employees. We propose to deal with these allowances in any of the later volumes of our report. Then, Lord, 10.2. Now we first deal with dearness allowance. Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by Pay Commission gets continuously eroded with the passage of time. Thus arises the need for payment of dearness allowance so as to protect this loss. Now, my lord, this is a rationale for dearness allowance. This is not, my lord, disputed by the state. The state does not say that there is no inflation. The state does not suggest that there is no increase in the cost of living. Now, my lord, please come to 10.3. The state government, since the 1st of April 1979, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of Dearness allowance. But almost invariably, there is a time lag in actual payment, and when the same is paid, the same does not include any arrears. Right now, only one such installment has remained, due which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from 1st March 2009, was sanctioned by Government of India with effect from 1/1/2008. A major grievance of most of the associations of employees has been non-payment of the DA installments in time, as per Government of India's policy. This is payable twice a year, with effect from 1st of January and 1st of July each year. They are also agreed because of non-payment of arrears. As per information available, we find that apart from notionally allowing the pending installments at the time of the pay revision in the years 86 and 98, the actual payment of DA during the years 97 to 2008 has been as under. Then, my lord, 10.6. It is evident from the above that state government sanction of the installments does not follow any definite pattern. It is clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the government with effect from 1st July 2008, and then, these are the critical words, my lord, fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all employees within our terms. Now, my lord, before I show you the rules, there is a notification which explains, my lord, how this pay commission came to be constituted, how it has submitted the report, and how has the government viewed it, and how the rules have been framed. May I show that straight away, my lord? Your lordships will find this is annexure. This is, my lord, annexure P3. Well, there are 2 memoranda. One of them is numbered as 1691F, and the second one is 1692F. But let's take, my lord, the first one, which is 1691F. That your lordships will find is at printed page 155. That is, my lord, if I may say so, it's the scanned copy. May I take you, my lord, to the better version, the typed version, which is at printed page 162.
Yes.
Subject clarificatory memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and on allied matters dealt with by the 5th Pay Commission. In Finance Department resolution dated 28 August 2008, the government constituted a pay commission to examine the present structure of pay and conditions of service after taking into account the total package of benefits available to the following categories of employees and to suggest changes which may be desirable and feasible, keeping in view the decisions of the central government on the recommendations of the 6th Central Pay Commission. And now, my lord, after this, your lordships will find over the page 163, just above para 2, the commission submitted its report on the 12th of February 2009 after due consideration of the recommendations of the commission. The governor has been pleased to make the decisions set out in the following paragraphs in respect to the employee under category 1A above. Scales of pay. The government has accepted the recommendation of the Commission in respect of running pay bands and grade pay corresponding to its scale of pay without any modification. Now, my lord, the next matter is important. The revised pay structure, which has been prescribed by the government, is set out in Schedule 1 to the ROPA Rules 2009 relating to services generally published with the notification 1690F. Then, my lord, the various rules and regulations. And then these have been, my lord, published in the Gazette. Now, here, my lord, your lordships will find, please now just scroll over to the most important part, my lord, which is at printed page 166. 166.
Clause 10.
Clause 10. And the most critical part, my lord, of clause 10 is this. Consequent upon revision of... Sorry.
Yes.
This is 166. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the Dearness allowance which a government employee is entitled from time to time since the first day of January 2006, because that is the date of the Central Pay Commission, 1/1/2006, needs to be related to pay in the revised pay structure. Now, my lord, your lordships may kindly see the crucial words are the Dearness allowance to which a government employee is entitled from time to time. Since the 1st of January needs to be related to the pay in the revised structure. This is, my lord, in response to my Lord Justice Mishra's question, that how do the three clauses work? Because the word is aggregate first. It is 1 + 2, on which, my lord, there is 3. Then please see, now this is, my lord, quite important. And this is how, my lord, the rule needs to be looked at. Now we come to the rules. Now please see now, my lord, the rules.
Sorry, 1 minute.
Yes.
The government notification of 23rd of February is at what page?
Yes. That is, my lord, that is the next annexure, my lord, which is 1692F. I'll place that too at this juncture. And this, my lord, actually, if I may say so, completely buttresses the position of the respondents. Please see, consequent upon the revision of pay scales of government employees, my lord, that is printed page would be 168. I think there is also a typed copy which has been provided, which is at printed page 170. 170, it's easier on the eyes. The governor is pleased to decide that the full-time state government employees...
That's something else. That's something.
Oh, sorry.
You have to read from...
Oh, I have to read from that, yes. Yes. I'm grateful. Well, please therefore come back to 168. Consequent upon the revision of pay scales of government employees under the provisions of the West Bengal Services Revision of Pay and Allowance Rules 2009, it has become necessary to relate, well, this expression, to relate Dearness allowance admissible to a government employee to his basic pay in the revised pay structure in the case he has elected or is deemed to have elected to draw pay in the revised pay structure prescribed under the aforesaid rules. As has been laid down in Rule 12 of the West Bengal Services Revision of Pay and Allowances Rules 2009, that no areas of pay and allowances to which any government employee may be entitled in respect of the period from 1st of January to 2006 to 31st March 2008 shall be paid to the government employee. The Dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st of April 2008 only. So, my lord, while the revised pay structure would be worked out with effect from 1st of January 2006, but you will get no arrears. And from 1st of April 2008, that is, my lord, the newly revised pay, you will be entitled to Dearness allowance. Accordingly, the governor is pleased to decide that the Dearness allowance payable to a government employee with effect from 1st of April 2008 shall be at the following rates. And your lordships will find this 2%, 6%, 9%, 12%, 16% are the percentages given by the central government, although it was with effect from 1/1/2006. So, what is important is that time to time. That is reflected in this very notification itself. 1/4/2009 onwards, it says 16% and it leaves it at that. Now, my lord, let us go to the rule, because this really is the subject of interpretation in our case. Please come to the rules. The rules are, my lord, they begin Annexure P2 at printed page 100. And if your lordship sees,
yes,
in the foreword, which is at printed page 101, it says the West Bengal Services Revision of Pay Allowances Rules 2009. Sorry. That is, my lord, forward. But it's important to show that page, my lord,
better if you read 125.
Yes.
That is the legible one. Yes.
I'm grateful, my lord.
Yes.
I'm very grateful, my lord. The West Bengal Services Revision of Pay and Allowance Rules 2009 and other notifications on revision of pay of police personnel, civil defense personnel, staff and officers of the Public Service Commission, West Bengal, as well as a memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009, and allied matters have been published in the extraordinary issue of Kolkata Gazette, dated 23rd February 2009. Government has also issued orders sanctioning fresh installments of Dearness allowance with effect from the 1st of April 2008. My lord, it should be not 2009. That I think is an error. It's April 2008. So, my lord, now we come to the rules. Let us see the rules.
There is no error because the original one says 2009 only. We really don't know why.
Yes, my lord, but the rule is from 1st of April, as your lordships have seen, 2008. Now, please come to, my lord, printed page 126. Please see 1-2. They shall be deemed to have come into force on the first day of January 2006. That, my lord, coincides with the central government, the 6th pay commission of the central government. Then please now, my lord, come to rule 3. In these rules, unless the context otherwise requires. Now, my lord, nobody has pleaded that there is a context which otherwise requires to depart from these definitions. Please keep that in mind. Now, my lord, the first is existing basic pay. Existing basic pay means the pay drawn in the prescribed existing scale of pay, including stagnation increments, if any, but does not include any other type of pay. And then, my lord, we have that expression existing scale. Then we come to existing emoluments. Existing emoluments mean the aggregate of, which is, my lord, it's the total which has to reach an employee. But it has different elements. The first is existing basic pay, that is, my lord, the unrevised pay, Dearness pay appropriate to the basic pay, and Dearness allowance appropriate to the basic pay plus Dearness pay at index average 536, 1982 is equal to 100. Now, my lord, the use of this word index, my lord, index itself, my lord, it's a Latin expression, it means a pointer. This index is really the pointer. And how do you calculate the dearness allowance? It is with reference to this numerical 536, 1982 is equal to 100. That is, my lord, 100 rupees of 1982 today is you need 536 to draw the value of 100 rupees which you had in 1982. Now, my lord, your lordships will notice, and that there is actually, my lord, a calculation which I made. It is clear, my lord, from all the rates declared by the central government, they have used this formula, and this formula is the other side as well. This formula, my lord, shows that the denominator is always 536. So that figure 536, which your lordship saw, is critical. Please have a look at this. Please see, my lord, please see for a moment column H. We are now talking of April 2008. In April 2008, my lord, the DA given by the central government was 12%. Does your lordship find that in column C?
Yeah.
I'm sorry.
Yes.
It was 12% in April 2008. My lord, we got 2%. Then, my lord, the balance was 10%. Now, my lord, what is the formula for calculation of central government DA rate as reflected in column C? It is 605. That is, my lord, 536 had gone up to 605.
Yes, yes.
This 536, my lord, the AICPI index rose to 605. So, my lord, you divide it by 536. And you also deduct that 100, because 1982 is equal to 100 has already been subsumed. That is how you get, my lord, 12.87. But, my lord, they now forget the decimals. They give it closer to, that is how, my lord, it is done. So each of these, your lordships will find, January 2009, 22%, and, my lord, we got 9%, but the calculation in H is 656. Sorry.
No, sorry.
656 upon 536, keeping in view 100, that comes to 22.39. So that figure, that average index, which says 536 within brackets 1982 is equal to 100, is, my lord, the factor of calculation at each point of time when the index changes. Now, please see the next one, 727 divided by 536, and again offsetting 100, you get the percentage 35%. 815, again, my lord, you get 52%. Then 887, you get 65%. So, my lord, there is actually a scientific, it is almost like an actuarial calculation. Please then turn over the page. In January 2013, the figure, my lord, becomes 969. That takes you up to 80.78%. Then, my lord, in January 2014, it increases up to 1075, so 100.56%. Then January of 2015, it goes up to 1143. That is how it comes to 113%. In January of 2016, it goes to 1210. And so on, my lord. Your lordships will find the calculations are available right for all the revisions done by the central government using the AICPI index. So, my lord, this average is done only by the central government. Now, if you look at the structure of the rule with me now, my lord, the words are important. Dearness allowance, the crucial word, my lord, here is appropriate. That word appropriate means it must be appropriate to the basic pay plus dearness pay at index average 536. So, my lord, this index average 536, if 536, my lord, undergoes a change, then taking into account 536 as a denominator, you work out the percentage of increase. This, my lord, is really the purpose of this particular rule. So, my lord, instead of even taking a position that this is an implicit arrangement in the rule, my submission, my lord, is that this is explicit because it is A, an aggregate, B, it is appropriate to the revised pay, C, at index average. And that index average, my lord, once you say index, it means, my lord, that that average will move according to a change in 536. And that is why, my lord, that para 10, which I showed to your lordship, said, time to. So this, my lord, is really the reading of the judgment of the division bench of the High Court. But, my lord, there was one other question which arose before the division bench. There were employees, my lord, of the government of West Bengal who were governed by the ROPA rules. But fortuitously, some of them, my lord, were working at the Bonga Bhavan in Delhi. Some of them were in a youth hostel in Chennai. And, my lord, they were being granted actually the Dearness allowance exactly on the basis of the central government rates. Now, that was an additional factor for the court to say that this is a case of discrimination because they are governed by the same rules. And there is no difference, there is no intelligible differentia that they should get a higher. But it was taken into account. But it was not, well, not the primary reason for applying. The primary reason is that in the very nature of a Dearness allowance, if it is meant to offset, my lord, cost of living increase, the increase, my lord, in essential commodities, my lord, it is done also in a very scientific way by the Bureau of the Labour Ministry. They, my lord, actually get data from the Ministry of Consumer Affairs every month on every item. And, my lord, why they apply industrial workers is they take, my lord, much lesser in terms of, that is, essentials, basic essentials which are required. But if their prices have gone up, then, my lord, they take data from all over India and make an adjustment. And this adjustment, my lord, like even today, as we speak of yesterday, my lord, the central government for the festive season, but because the AI CPI index went up, gave, my lord, a 3% increase to the employees. Now, what I'm saying, my lord, is that this is on the basis of understanding that Dearness allowance is not a matter of race. Dearness allowance is integral for the real value of a wage. So, my lord, if the real value of a wage has to be protected, of course, my lord, if the state of West Bengal, let us say, had a Mahalanobis formula, a different formula to actually calculate Dearness allowance, it's very different. My Lord Justice Mishra asked an extremely critical question yesterday. What was the basis on which you changed? What was the working? The working, my lord, for a good part of time was only the central government's, but it was, my lord, postponed, as your lordships have seen. So, my lord, the issue is, if the rule gives this method of calculation, is it not binding on a state government in terms of the emoluments which have to be available to a government servant? In addition to this, my lord,
can you provide us an exemplar of an employee working at Bang Bhavan in Delhi or at Chennai being paid DA in terms of the central government rate?
Yes, my lord, I have
an exemplar.
Yes,
of
yes.
any employee.
Yes, yes, my lord. Yes.
Who is working in Bang Bhavan vis-a-vis the same cadre of employee getting a less amount of DA if he is working in Calcutta.
Exactly. Lord, I'm showing you the chart. I'm deeply grateful. Please come, my lord, to a chart. Yes. Please see, my lord, Annexure CA2, which your lordships will find is at PDF page 895, but it might be printed page 17. It's a part of the counter affidavit of the second respondent. It is an annexure, my lord, CA2. And this has not been disputed. C1.
It's a counter affidavit?
Yes. Of respondent 2, my lord.
It's mine, my lord, and it's not been disputed.
Yes, yes. This draft is extremely useful. I'm taking advantage of the material available for us.
Counter of respondent number 2.
Yes, my lord.
Page?
Printed page, my lord, this would be 17. Printed page 17. Annexure C1.
Yes, please.
Now, your lordships will notice that at page 17 is the chart. Chart showing the discrimination of payment of dearness allowance between the state government employees working at Bonga Bhavan, New Delhi, and Youth Hostel, Chennai, and West Bengal state government employees working in the state of West Bengal in connection with ROPA 2009 and 2019. Now, my lord, your lordship sees April 2008 is from when, my lord, we were entitled to a pay. 1st April 2008. We got 2%. Is your lordship able to see that chart? We got 2%. Your lordships recollect that in that notification. My lord, Bonga Bhavan, they applied the central government dearness allowance and gave 12. Similarly, my lord, all the payments which your lordships will see in column number 3 are exactly those of the central government AICPI. Well, this is not even one exemplar. This is continuing from 2008. All the way your lordships will find what was it which we got in the last but one column, and what is it, my lord, others who were also governed by the same statutory rules. What did they get? So, my lord, the suggestion by the state that they don't know how to calculate this is certainly not wrong, because they are the ones who gave this. Please see 27, 35, they followed strictly, my lord, all the way, as your lordships will find, right up to, all the way, my lord, I'm now going to take you right up to 2019, December 2019. They got exactly what was available in terms of the calculation of that formula for the central government. So this is the point, my lord. And this is not merely a case of incidental discrimination. This is a case where the same employer, for some of its employees, is making available dearness allowance exactly, my lord, ditto of the central government based on this formula. So, my lord, the point which is being made by Mr. Devar, that it was static, it became fossilized on the day, well, as I said, in any case, the pleadings, my lord, are in fact inconsistent with this. If your lordship see the judgment of Justice Samalto and Justice Tandon, the two learned judges, nowhere, my lord, is there a suggestion that it stood frozen at a point of time, because, my lord, dearness allowance in its very concept is a variable allowance. This is the point.
Is there any separate GO issued by the government of West Bengal in respect of the Bonga Bhavan employees and Gujari employees?
No.
I think there is, my lord, judges.
I speak subject to correction. Page. Annexure 31, my lord, I'm given to understand, of the page 31. Please go to page
of the same one.
31 of the counter.
Same counter of R2.
Of R2, my lord.
Page?
It's page 31, my lord. Annexure C2. Well, this is actually with reference to the ROPA rules of 2019. This is the second section.
But it continues the same problem.
My Lord, I want to make one thing clear. These cases are governed, my Lord, with reference to the ROPA rules of 2008-9. 2009 rules, my Lord, are the issue in this case. But even after the ROPA rules of 2019 came, it's important to see, my Lord, this very significant point.
No, this happened for the first time in 2019.
That is because the 2019 rules, my Lord, did away with Dearness allowance in the rule. So what they did was, they issued this order consequent upon the revision of pay and allowances of state government employees with effect from 1st of January 2020. Under ROPA rules 2019, Governor has been pleased to order that the state government employees posted in New Delhi will draw Dearness allowance, house rent allowance, so and so, with effect from Dearness allowance at the central government rate. So, my Lord, although the new rules abolished Dearness allowance, but they followed that same pattern of giving the central government DA in respect of these employees. And, my Lord, the 2019 rules are not the subject here today because, my Lord, still discussions are going on. The Pay Commission, which dealt with the 2019 rules, my Lord, the report was published only 2 months ago. So that is being examined, how to deal with that. Because, my Lord, that actually did away with Dearness allowance. So notwithstanding Dearness allowance disappearing from the 2019 rules, they continued to give, my Lord, the central government DA.
Presently, they are not getting DA.
Where, my Lord, they were getting, no, now, my Lord, now after a period, that is the new rules of 2019, my Lord, they were notified in September 2019 with effect from 1/1/2020. With effect from 1/1/2020 for a period of almost 2.5 years, we didn't get any DA. Then, my Lord, there has been small driblets of a minuscule percentage which has been given to us as a Dearness allowance. Which is why, my Lord, it is important to state the point that, my Lord, this is not gratis. This idea that Dearness allowance is something which is gratuitous.
The methodology is the same.
Exactly.
2006 to 2008.
Yes.
Nothing was paid.
Exactly.
Again, 2019 to 21.
I'm grateful.
Nothing was paid.
Exactly, Below. This is the point.
They are saving it.
Yes.
Like old days money lenders.
So, I couldn't.
Businessmen.
Yes.
Use the money
yes.
to others.
Yes.
For their own business.
Below, for 2 years, not to pay you from 1st of April 2008 and give you in driblets. That is, my Lord, what was given in 1st of January 2006, you're making available to me in 2008. So, my Lord, this is the real case.
Perhaps you can, let us know.
Yes.
The counter affidavit filed by
respondent to
page 16 and page 31. These are documents of the year 2022.
Yes.
And 2020. Is there any document available on record, or perhaps you can place?
Well, may I just search the record and give you a yes?
We are interested to know between the period 2009 and 2009.
Yes, 2009 up to 19.
That would be. You may not answer immediately.
I'll just yes, certainly.
My lords, we do actually have it.
That is reflection. We know that. But we just want to. Just look into it.
Yes, we'll do that. My lords, we have it.
If you don't have it on record, doesn't matter. You can still give it to us.
Certainly, but we just.
You know that. In 5 minutes, give us 5 minutes.
Certainly.
Yes.
May I have your notes graciously, my lord?
Please.
My lord, we found a document. It is, my lord, a part of the additional documents which, my lord, we have located, which is at page 126, R2A, on 8.
Yes, sir. Just flagged.
Page 126. Grateful to our public.
Please.
This is 6th of May 2009. Upon the ROPA rules having come in terms of finance department. Sorry.
Yeah, please. 126.
126, my lord. Printed page.
Just one. Yes, yeah.
Yes. This is 6th of May 2009. In terms of Finance Department memo dated 17th August 93, the state government employees posted are eligible for Dearness allowance, HRA and compensatory city allowance in terms of memo dated 14 January 2000 on the existing scale of pay at the rates admissible to the employees of the Government of India. Consequent upon revision of pay and allowances of the state government employees with effect from 1st of January 2006 under the ROPA Rules 2009 as promulgated through notification dated 23rd February 2009, the governor has been pleased to order that the state government employees posted at New Delhi will draw Dearness allowance, house rent allowance and the transport allowance in the corresponding revised pay structure in the following manner. Dearness allowance at the central government rate. Now, my lord, please mark these words. With effect from 1/1/2006, actual payment will be made from 1/4/2008. So, my lord, in respect of these employees, they shifted the goalpost and made it with reference to the central government rate. House rent allowance and so has been allowed by the Government of India to its employees and so on. Well, this order was noticed by the tribunal, and the tribunal, my lord, records a finding in the judgment that it is an admitted fact that throughout these employees who were in Banga Bhavan and in the youth hostel did receive the DA on that basis.
One query.
Yes.
To both Mr. Diwan and me. Now, is this in terms of or under ROPA, or is it in excess of any other power constitutional or other power? We just want to know.
Yeah, I completely understand. But if the rules occupy the field and their revision of pay has taken place under these rules. So if the revision of pay, my lord, takes place under the rules, it is, my lord, logical. It's a concomitant sequitur that the Dearness allowance also must be under those rules.
See the areas.
And please see, my lord, they expressly refer, consequent upon revision and pay allowances of state government employees with effect from 1st of January 2006 under the...
Even the areas are according. Even the areas are according.
Yes.
You read it. The question was purposely put to both of you.
Yes.
For you to respond to.
Yes.
You read it.
No, but now, let me answer that question. Once you have rules.
So, according to you,
yes,
there are rules spreading the fee, and therefore the excess of the power has to be and is in fact
not
rules. That's just
that is the answer. In other words, there is no residuary executive power which is vested in the governor to either bypass the rule or improve upon the terms and conditions. That doesn't exist once it is covered by the rule. And it is also common ground that these employees were in fact governed by the ROPA rules. So we have within the ROPA rules, these were clamoring for this determination of Dearness allowance, and we have another set who are being granted exactly as per the central government deal. Now, my lord, the point is, this formula, my lord, the reason why I mentioned 3C3, appropriate, the word appropriate means that it is based upon this index. This index, my lord, is a base. 536 is a base, which is why your lordship saw in the chart, in the entire chart, every calculation has 536. So, therefore, my lord,
one more.
Sorry.
Query which comes to
Please,
my mind.
please.
Is this page 126 document?
Yes.
In exercise of the discretionary power vested with the government under OPA?
The discretionary power, incidentally, no, because under the ROPA rules, may I show your lordship's rules 12 and 14, because they actually have overriding effect. Because they have overriding effect, you cannot have anything supplement because of rules 12 and 14.
What you're saying is any which way.
Yes.
Any which way.
Yes.
This is under OPA.
That's right.
And therefore, section 3, Roman 3 has to be read the context in the background and the control.
Now, in other words, now let me put it the other way. How is it, for now the state could have said, for them, they have said that this is a different, they're living in Delhi, they're living in Chennai. But let us look at it differently.
Because the cost of living in these two cities
is
obviously high.
Yes. Let us, that is true, but then they are state government. But the point is slightly different. The point is, 3C3 contemplates a determination. That determination, my lord, has also been worked out. What I'm trying to say is, it is not that there was only one way they understood this rule. It is not that they understood this rule only in the way it has been preached to us, namely that it was frozen and I have discretion thereafter to give you what I can and when I can. They, in respect of these employees, in terms of both the working of the formula under 3C3 and the time for which they gave it, this extensive period of time, until my lord finally the tribunal said this is discriminatory and the High Court struck it down. My friend said we have not appealed against that portion of that order. Fair enough, but the fact remains, we are looking at a period, my lord, which is up to 31st of December 2019. That period cannot be effaced. The period from 1st of April 2008 to 31/12/2019, which is covered by the ROPA rules of 2009, this persisted right through. And if it persisted right through, it is below a circumstance to take into account that is it really possible that the state government did not know how to work out, shall we say, the dearness allowance payable. And my lord, it is also not their case that this dearness allowance which they gave to these employees in Banga Bhavan and these are not based upon the working of that 530, 539, 536. It is also not their case, my lord. It is not a case that they have adopted a formula, central government, but the point is, at no place, my lord, has the state said that if you calculate appropriately in accordance with the All India Consumer Price Index, IW, the result would be the rate which we have asked for, which was determined by the central government. And my lord, AICPI, that rate, is a yardstick. It's a norm. But if you embrace that norm, you must abide by that norm. Well, in terms of even, it's not only a matter of good governance, but as a matter of law, if you embrace a norm, as you're holding out, you are stopped from suggesting to the contrary, because there is a rule. And that is why, my lord, this is an obligation under a rule. And since it is an obligation under a rule, it is a statutory obligation compellable by mandamus. Now, my lord, an argument was raised. How can the tribunal do some quick footwork and come to this conclusion and issue these panoply of directions? My lord, really, That was done by the tribunal in respect of, my lord, a vexed question that should they get it twice a year or should they get it once a year? And, my lord, there was silence. There was nothing very clear. They said the way in which even this Dearness allowance has been released partakes of an ad hoc and whimsical character. And if it is ad hoc and whimsical, it is important that there should be some norms. Whether it is once a year or twice a year, we suggest it should be twice a year. The Pay Commission said twice a year. The rule, my lord, doesn't forbid twice a year. And, my lord, as a matter of fact, in that document of 23rd of February 2009, your lordships will see they have also given it sometimes when it pleases them, twice a year. So, my lord, this is the point. They cannot be, my lord, surely the arbiters of destiny when it is not only a matter of contract, but, my lord, an employee of the government, it is a matter of status, governed by the rules.
Can you...
And, sorry, so sorry.
Sorry to disturb you.
No, my lord, I was just telling my learned friend, I think it's after quite a few years, we've seen two advocates general, eminent advocates general, my lord, sitting and adorning the bench in this court. It's after quite some time, my lord.
Can you show us the language of the central revision of payrolls?
Central revision, yes, certainly.
ROPA,
yes,
we may call it central
yes.
ROPA.
Yes, yes. In fact,
is the language in central ROPA?
Yes.
Vis-a-vis the dearness allowance.
Certainly.
Whether they also use this index average of 5%?
Yes, yes. Yes, my lord. In fact.
And whether there is any reference to AICPI in the central rule?
Yes, yes, my lord. Because even the latest 3%, which was announced yesterday, is based upon, my lord, the AICPI index point moving upwards. And, my lord, it moved actually, my lord, the basis has slightly changed, but it is AICPI.
AICPI is mentioned in the rules itself, or AICPI is mentioned in the notification?
Separate notification for the central government
is given an inquiry.
I'll just verify it, my lord, and then make an accurate statement. But I'm very grateful, my lord, because the central government, my lord, is also a government. It is a government established under the constitution and our federal setup. And, my lord, it also follows a method. Sorry, I'm so sorry. My Lord, I'm deeply grateful to my Lord Justice Mishra. We have the rule, my Lord. I'll just hand over copies of it. This is, my Lord, the Central Civil Services Revised Pay Rules of 2016.
You have copies?
Yes, my Lord. We're just getting it, my Lord. My Lord, this expression, existing emoluments, occurs even in these.
Index provided?
Yes, yes.
Can we just read?
Yes, yes, my Lord.
Can we borrow your laptop?
My Lord, may I read out first?
Can we just borrow it?
Please, please. Existing emoluments, and your lordships will find.
Is it paramaterial?
Paramaterial, my Lord, it has an index average.
No, but this denominator at index average 536 is not mentioned.
Which one, my Lord? But that is because, my Lord, this index average is this AI-CPI, IW average. Over 2016, please. I have actually brought the earlier rules, which are the 2008 rules, my Lord. In that, your lordships will find it expressly refers to the index average 536. I'm grateful to my present.
Index average depends on the period when it is considered.
Yes, it is put out.
So this, because this narrows down to
completely
consideration.
Yes.
Whether AICPI is only a method of calculation or AICPI itself is central DA.
I'm deeply obliged. I'm deeply obliged.
Whether we understand the word AICPI to mean central DA, the rate of central DA.
Yes, it happens not to be the same. Because if you work on that formula, you will get at the same.
Because the language is the same.
Yes, yes, yes.
They say, according to the West Bengal government,
yes,
this definition of existing emolument,
that's right,
excludes application of AICPI.
That's right.
According to them.
Which is why I wanted to show you what this rule is. This rule is identical. So, my Lord, what this implies is...
Now, be ready, you have to answer this.
Yes. So, my Lord, what needs to be understood is that this is therefore, my Lord, an evolving. But when we say index...
And you have not developed your case.
Which one?
You have not developed your case like this. You means your...
My Lord, I must say...
When it comes from the court, we have to answer.
My Lord, with respect, my Lord, I'm obliged. To be very honest and, my Lord, to be candid, I did not think through this point. I'm obliged. I'm being honest, my Lord.
No, just it's a way of thinking. It may not be.
No, but but the important point is, which your lordships asked me, is that what is AICPI and is this index, this average indexing? That's one of this word, both average and indexation, they have meanings.
Then now comes the question.
Yes.
Where is this enabling provision or enabling instructions available with any government to calculate the DA basing on AICPI?
Well, that is because this 536, which your lordship see, is actually only from AICPI. Well, let me explain this a little. This AICPI, Lord, is an exercise undertaken, it is not belongs to a private agency. It is undertaken by the central government itself in its two departments, the Lord of Consumer Affairs and Labour. And what they do, my Lord, is this. They apply, my Lord, different bands. But for industrial workers, that is the basis, my Lord, for this revision of Dearness allowance. And, my Lord, what they do is that they calculate and then they calculate what is the extent of variation. And if the variation is substantial, it's not that, my Lord, they don't sometimes give it immediately after a little increase. There might be a gap between one increase and another increase. So what they do is, they actually give this percentage based upon these indices. So, my lord, this All India Consumer Price Index, the ascertainment of this average index is a governmental function. And at this moment, it is being performed by the central government. In some of the cases which my learned friend referred to, which deal with industrial disputes, well, there are some references to Dearness allowance, but government servants, well, are bound in some sense by a determination of a formula by the central government because it is an all India. Now, I am not saying, well, for a moment, that they could not have come up with another, if I may say so, rational formula. But if they choose to adopt the central government, and which is what your lordship saw, they have been doing since 1979 in the Pay Commission's report. So consistency demands that you come in alignment with it. That is what the Pay Commission recommended. So for the state government today to say that it is frozen, and after which I will only give, your lordship asked again the critical question, tell us what basis did you work? Where did you get the rates from? If you decided to give 2%, where did you get 2% from? 5% from? Well, there is no suggestion in any affidavit that they did some independent work for the purpose of ascertaining the consumer price index, West Bengal, and they came to different conclusions and their statistics were different and they formed a model. That is not their case. This 536, they also acknowledge that this is All India Consumer Price Index. Well, they say, which is why your lordship saw in that note of Mr. Divan, item number 11 yesterday, he admits that this is the All India Consumer Price Index. Then, the word index, in the very nature, clearly shows it is a pointer, it is an indicator, it is like a formula. In fact, that word is now used in computer, algorithmic. But it is an indicator. And why does it use the word average, Because this average of 536 was for all the 12 months which preceded that 536. So, they take a weighted average of the entire year. And that is that final figure which your lordship see in that column. So, the question is 536 within brackets 1982 is equal to 100? Does it not furnish a clear mathematical formula? That is the point. If it does, it is a formula, it is exact, it is precise. Well, it is not left to discretion. It is a precise way of calculating it. And, it is not suggested that Dearness allowance is not for the purpose of offsetting cost of inflation. It is also not suggested that this formula, if worked as a formula of indexation, then in that case, you will arrive at proper mathematical percentages, as we have shown in that chart. And, it is not that they could not use or prepare this chart. Please take this. It is not that, they were not aware of this chart, because it was on this chart, on the basis of this calculation, they, gave those employees this particular rate. So, this is, if I may say so, the summum bonum as far as the case is concerned. Now, as far as the legal position is concerned, there were some judgments which were cited. I first want to just sum up the principles. The first is, a report of a pay commission is entitled to wait. However, it is not binding as a matter of law on a state government. Third, the government has got discretion to accept it in part or in total or even reject it. It is entirely up to the state government. To that extent, the prerogative of the government, I'm not questioning. But now, the next question is, if you do have a pay commission report and you accept the recommendations and you frame rules, then in that case, and that crucial words, time to time, Dearness allowance from time to time, clearly means, that this is an average index which will be moving. Once 536 changes its position, that number, but with reference to 536 as a base, you will calculate dearness allowance. Now, my lord, the law is if there is a rule, your lordships have said, if there is a rule and the rule obliges you to pay arrears, and my lord, one must also take into account that dearness allowance revision affects not only serving employees, it affects pensions. And that is another factor, my lord, which is why it has to be in the form of a concrete rule. The last point is, my lord, when you have a clear-cut rule, then I submit any reliance upon grace or any reliance upon discretion or any reliance even upon what is, my lord, being pleaded as financial, my lord, no government is truly impecunious, if I may say so, my lord. It would be a contradiction in terms. It would be a contradiction of the very idea of sovereign governments. But suffice it to say, well, these are matters which they have to find solutions. Well, these are matters for which they need to find solutions. But it is not, my lord, open then to the government, and your lordships have held, and my lord, there are judgments in various cases, your lordships have said, that this financial liability is an oft stated argument and is liable to be rejected when it comes to, my lord, enforcement of a rule of obligations which are imposed by law. My lord, this is the gamut of my submission. I will make sure that, my lord, our written submission is updated so that, my lord, it is presented. My lord, if there's any question your lordships wish to ask, I'll be more than grateful.
The decision will...
Yes, my lord, I have put it in the note, but your lordships may take it. I summed it up, my lord. I don't want to read extracts of this. I know, my lord.
See, that constitutional judgment of Mr. Howard.
Which one, my lord?
MP judgment, 1956.
1954. That's right, my lord. Yes, Mandava. Let us look at that, my lord.
Yes.
I wanted to show that. In fact,
if you come to Mandava,
there is actually a sentence which helps me, my lord. Let me show.
121, compilation, page 120.
Yes, my lord, I'm just. Yes, my lord, please look at this judgment. Well, this judgment, if your lordships will kindly see the para which was relied on, please come, my lord, to paragraph 4. At this would be, my lord, printed page 974, but it is in the compilation. Please see that paragraph 4.
Yes.
On the first question, Rule 44 of the fundamental rules runs as follows. Subject to any restrictions which the Secretary of State and Council may by order impose upon the powers of the Governor-General and Council or the Governor-General and Council, as the case may be, and to the general rule that the amount of a compensatory allowance should be regulated, that the allowance is not on the whole a source of profit to the recipient, a local government may grant such allowance to any government servant under its control and may make rules prescribing their amounts and conditions under which they may be drawn. Under this provision, it is a matter of discretion with the local government whether it will grant dearness allowance, and if so, how much. That being so, the prayer for mandamus is clearly misconceived, as that could be granted only when there is in the applicant a right to compel the performance of some duty cast on the opponent. Well, these are the crucial words. According to me, there is a duty cast on the opponent. Rule 44 of the fundamental rules confers no right on the government servants to the grant of dearness allowance. It imposes no duty on the state to grant it. It merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus can issue to compel the exercise of such a power. Nor indeed could any other writ or direction be issued in respect of it, as there is no right in the applicant which is capable of being protected or enforced. Then, my lord, thereafter, it is on this basis that they proceeded. My lord, the rule is actually for a very different purpose. This is in respect of local government. It is in respect of compensatory allowance. There are words which signify discretion. But, my lord, the learned judge is conscious that if it is a duty, then it goes out of the domain of discretion. My lord, if it is a duty, then it is no longer the subject of any discretion. Sorry, so sorry.
You can
please. No, welcome.
Please enlighten us. If you come to para 3 of the report.
Yes, certainly, my lord.
What
Certainly.
of the
list
before the High Court?
Yes.
The High Court has held and what was argued in Supreme Court?
Yes.
And what is the decision of the Supreme Court?
I'm obliged.
Come to para 3.
Yes.
Come to para 3 and then answer.
I understand.
How do we
read that para? I appreciate. It's perfectly, my lord.
Yes.
We see para 3.
And exactly equate your case vis-a-vis
yes.
Banga Bhavan employees
yes.
with the argument and the case which was before the High Court in para 3.
Very well. Please see. In the petition, it was alleged that the state government should have uniformly adopted the Government of India rates for all its servants and the discrimination in making the twofold slab and accepting the Government of India rates for one slab, that is for servants receiving salary over rupees 400 and not accepting them in respect of the other slab, that is of servants below rupees 400, is highly discriminatory, that the state government has a right to be treated, state government servant has a right to be treated equally with the central government similarly situated, and that every servant has these fundamental and natural rights, and the petitioner and the members of the Ministerial Services Association have a right to demand from the respondent the dearness allowance at the Government of India rates. The petitioner then prayed that declaring that all ministerial servants are entitled to the Government of India rates, the state government should be directed by a writ of mandamus or any other suitable writ of direction to cancel the discriminatory rules of dearness allowance and adopt the Government of India rates to all servants without discrimination, or in any case to provide with adequate rates of dearness allowance sufficient to provide reasonable subsistence for them. The government contested the petition on the grounds, firstly, that the claim for dearness allowance was not justiciable, and secondly, that the difference in the scales of dearness allowance adopted by the Commission and by the Committee did not violate Article 14. The learned judges, Chief Justice Sinha and Bhatt, held that under the rules, dearness allowance was placed on the same footing as pay, and the claim relating thereto was therefore justiciable, and that the differentiation made between the employees of the central government and of the state government in the matter of grant of dearness allowance rested on no intelligible and reasonable basis, and that the resolution dated 16 September 48 was therefore banned. They accordingly issued a direction to the state government that they do reconsider the question of dearness allowance payable to the employees concerned. It is against this judgment that the present appeal has been prepared by the state government on a certificate granted under Article 132(1). And para 4 also.
Now, with this principle in para 4, they have allowed the appeal.
Correct. Now, my lord, please keep one thing in mind. In para 4, it is argued on behalf of the appellant that the grant of dearness allowance is a matter ex gratia and not justiciable, and that neither a writ of mandamus nor any direction could be issued with reference thereto. Now, my lord, there are two answers to what my lord, the Honorable Justice Mishra put to me. Let me apply, my lord, that Bang Bhavan and this. But, my lord, that is a case where we are two people under the same government. The important thing I want your lordships to appreciate is we are not claiming, my lord, the A on a principle of parity with central government employees. This is very important, my lord.
No, you see, but we, the destination
yes,
which you want to reach,
yes,
is the same.
Well, that is
the only by way of process of interpretation.
Yes.
You is compelling the court or praying before the court to issue a writ of mandamus.
May I say, I
am understanding the central DA.
Yes.
By applying this AICPI.
Yes.
Without mentioning that give us central DPI, central DA rate.
Yes.
You are saying apply AICPI.
Yes.
But it boils down to the same thing.
Well, the result, as your lordship said, the destination, if I may say so with respect.
The only argument which can save you is that we are not playing anything over and above what the rules say.
What the rules say.
That is what your argument
Yes.
is. And if the rules permit this, then it is an enforceable thing. We are not demanding anything new.
Well, not only this. Yes. If I may say so, the fact that this coincides with the rate of the central government is not the fulcrum of the claim. In other words, my lord, if I claim parity with another person because I say we perform the same functions, then all the judgments which Mr. Divan cited would all become applicable. I am saying that this is only a matter, this is the outcome. But the outcome, the process of the outcome is the rule. In other words, my lord, the fact that I reached that destination does not mean that I actually, through an invidious process of reasoning, I'm claiming similarity. For instance, my lord, let's look at the revised pay structure. The revised pay structure of a central government employee, my lord, is different from the revised pay structure of a state government employee. But, my lord, only for DA, this formula is there because it is only a percentage of basic pay which is given, my lord, as an allowance. Therefore, my lord, I am saying, and my lord, this is a judgment in 54. In fact, Justice Madan's judgment in Central Inland Water Revenue, my lord, it's a classic judgment where the learned judge expounds on what we expect from a state in relation to its employees. Well, it's a lodestar. And the learned judge also says that we must not lose sight of the fact that employees, this doctrine of pleasure, fortunately, over the years, we have put some degrees of constraints in it. But otherwise, the hire and fire, or shall we say the erstwhile Henry VIII clause, that, my lord, is no longer possible under our constitutional scheme. So, my lord, even though we have a federal structure, but if under 309, my lord, rules of 30, proviso to 309, they are, in fact, my lord, this is the only provision where it is subject to an act of legislature. So, my lord, until the legislature passes an act, this is law which actually operates. And because it is law which operates, therefore, my lord, rights and obligations have to be determined in accordance with that law. And I appreciate my lord's comment that we arrive at that destination. But, my lord, that destination, if I may say so, works differently for both of us. It is only for the percentage we are the same. We are the same. But, my lord, it is a percentage of the basic pay, the revised pay. That is not an either. That is the point I make. So what is actually worth is only the percentage. And this, my lord, is a part of the expression emoluments. The reason why I'm very grateful, my lord, to my Lord Justice Mishra, as I said, my lord, I really I didn't think of the central government rules, but those rules clearly indicate in 2000, at that period, my lord, they clearly define existing emoluments with reference to this wage. So, my lord, this, if I may say so, is the farthest I think, my lord, I can
do you have that notification by the central government?
Yes.
Sanctioning PA by applying AICPI.
Well, it
is not in the rules.
We have the state government notification.
No, but we also have the
central
government.
Yes.
Give it to us now. Give it to us now.
Oh, Lord, it is in the rule itself, Lord, that your lordship wants to see the notification.
Because rule doesn't say the word AICPI is not referred in the rules.
Lord, this is index average. Lord, may I just explain?
Index average.
This index average.
Index average and AICPI is one and the same.
One and the same. Lord, there is nothing else.
There is nothing else.
It is the same language, my Lord. AICPI is.
There is only one index average.
Only one index average, my Lord, throughout the country.
Mr. Devan has given a document yesterday explaining what ASPI is.
Column
Yes. Yes.
Is there any notification to that effect is what we are asking? If it is so, you can give it to us after.
Yes. My Lord, in fact, my Lord, there are many notifications of the Ministry of Labour.
Just one.
Yes. Oh, yes, certainly. Certainly, my Lord, I'll produce that notification, how this is calculated. And my Lord, there's also a third ministry, I forgot, the Bureau of Statistics. Even that is involved in working out, my Lord, these indices. But your Lordships may take it. I'll produce the relevant notifications from the Government of India website in relation to AICPI and how it is. But your Lordships may take it that this index, my Lord, that is why throughout, even in the writ petition by the state, they took the position you are getting the Q of this All India Consumer Price Index only because of this Roman 3. That state government also.
In their note, he has mentioned.
Yes.
In their note.
Yes, in para 11. That's right. It expressly mentions. So, my Lord, this AICPI is the only way this indexation happens as far as central government and the pay commissions are concerned.
Is this?
Yes, my Lord, in the 2-page note.
11.
The AICPI index rates are alien to ROPA 2009, save and except only for the definition of a component of existing emoluments in rule. Yes. Existing emoluments in rule 31C3. My Lord, existing, my learned friend is referring to in present time. My Lord, existing emoluments means that the emoluments which shall exist under the ROPA rules.
That means alien, yet not alien.
Yet, that's exactly the point. Alien, but not fully alien.
Fully alien.
That's the point.
Yes.
And that, I think, my Lord, is with respect a contradiction in terms.
Thank you.
I'm very grateful, my Lord, extremely grateful. Very kind.
May I just supplement very briefly?
No, please, all of you this side, we are in no rush.
Yes.
Take as much time as you.
Because it is not going to be concluded in 5 minutes.
No, not in 5 minutes.
You will also argue.
Yes. So
Each of the principal respondent.
One minute. We told you, sir, everyone this side will have your turn. So whichever whoso.
kindly allow me.
You'll have your say, sir.
I won't take more than half an hour.
You may take as much time, we are in no rush, we told you already.
It's so great.
But don't repeat us.
No repetition, Lord. Since your Lordship is interpreting the concept of dearness allowance and dearness pay, just 2 paras from one judgment, and then I come straight to the point, on which your Lordships were debating just when my friend Mr. Subramaniam concluded. The compilation which they had given, please, the second judgment of the compilation, Bengal Chemical and Pharmaceutical Works, page 49. Please see that. Para 17 onwards. 4 paras I want to read, because that will indicate and perhaps may show some light on the way your Lordship will interpret Rule 3.
Yes.
Page 55, para 17. 4 paras only I will read. Before we deal with the contentions of the learned counsel, it will be desirable to refer to a few decisions of this court, laying down the principles that have to be borne in mind when a claim for dearness allowance or revision of dearness allowance is considered. So these are the principles which have been laid down. In so-and-so versus Calcutta Tramways, it was observed, we can now take it as settled that in matters of grant of dearness allowance, except to the very lowest class of manual laborers, whose income is just sufficient to keep body and soul together, it is impolitic and unwise to neutralize the entire race by cost of living in the cost of living by dearness allowance, more so in the case of middle class. So the concept of dearness allowance, because pays are fixed, this dearness allowance in its very basis is something which keeps on increasing, because the purpose of giving this to an employee is to neutralize the rise in the cost of living. Please see the next judgment, how your lordships have further explained. As pointed out in the Workmen of Hindustan Motors versus Hindustan Motors, the whole purpose of dearness allowance being to neutralize a portion of the increase in the cost of living, it should ordinarily be on a sliding scale and provide for an increase on raise in cost of living and decrease on a fall in cost of living. I pause here. It can happen, my lord, if inflation ceases and we go in, in fact we go in the reverse direction. When the formula is worked, it may even reduce. It is hypothetically possible, though practically never so as in the world we live in today. But the issue I'm wanting to flag is, one, it is to neutralize a portion of the increase in cost of living and should ordinarily be on a sliding scale to provide for an increase in the rise of cost of living. Your lordship can leave para 19, come to para 20. In Ahmedabad Mill Owners Association, it has been emphasized that in trying to recognize and give effect to the demand of a fair wage, including payment of dearness allowance to provide for adequate neutralization, industrial adjudication must always take into account the problem of additional burden which the wage structure would impose upon the employer, and ask itself whether employer can reasonably be called upon to bear the burden. In Kamini Metals, it has been noted that 100% neutralization is not advisable, as it will lead to inflation, and therefore dearness allowance is always a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Now your lordships is crystallizing what your lordships full neutralization is not normally given except to the very lowest class of employee. The purpose of dearness allowance being to neutralize a portion of the increase in cost of living, it should ordinarily be on a sliding scale and provide for an increase on the rise in the cost of living and decrease on fall in the cost of living. This is what I wanted to point out. So when your lordship will interpret this rule, this is the principle which your lordship would keep in mind, that the whole concept of dearness allowance abhors the notion of fixed allowance, because the whole concept and purpose being to offset the increase in cost of living and therefore sliding scale is the normal notion as your lordships have understood, not today, but from the very time when this concept was brought in. Now, with this background, my lord, now kindly see Rule 3. I have 4 points on Rule 3 to make to your lordships. I can start immediately after lunch because then it will be one.
How much time?
Half an hour, my lord, because I'm not going to repeat what my learned friend said. Half an hour. I just want to read some parts of the original CAT and the first High Court judgment. And yes.
I'll be half an hour after that.
So whatever time left for me.
No, you have all the time. We'll carry it out.
I will not take that after this argument, not more than 20 minutes.
Okay. So, anyone else who's to argue this side? So we move from the premise that today this side would conclude.
Yes.
We move, and then tomorrow.
After Mr. Patwalia, I shall take up and.
My lord, no difficulty. Even if you are not concluding today, we continue tomorrow. But we are just letting them know that tomorrow the hearing would begin. We would continue. That's all. Thank you.
Good.
Kindly allow me to deposit the directed amount in registry. I'm late by 1 day. I have to deposit on 5th and today is 6th month. Kindly allow me to deposit today.
Which matter, ma'am?
The matter number is 3179 of 2025. My Lord's order is of 21st July. This time will be tendered yesterday, my lord. Much obliged.
So, my lord,
My lords, before Mr. Patwalia starts, it is fallen for my lords that
No, I'm not.
You're frowning?
No. I'm only concentrating.
Okay. But with a smile.
Yes.
So, my lords, it had fallen from my lords that something from the central government that connects the AICPI to the Dearness allowance. And we have the annual report of the Labour Bureau that creates the AICPI that does so in detail. So, when my turn begins, I will place that.
No problem. I told you already.
Yes.
That's it. Rest of the board to be discharged. Rest of the board to be discharged.
Yes, our apologies. We had made it yesterday, clear yesterday, though, but not today. I don't think so. The council may wait in the other matters.
So, my lord, so far as the central government rules are concerned, we have got them, my lord. I can pass on the copy. Identical provision. Absolutely identical. Just pass on 2 copies. On the second page is Rule 3, which gives the definitions, and Rule 3, Sub-Rule 3.
Just 1 minute. Yes.
It's Rule 3, Sub-Rule 3. Existing emoluments means the sum of 1I is existing basic pay, dearness pay appropriate to the basic pay, and this is a fixed amount. Your lordship knows when the pay commission revises, it is basic pay and then dearness pay. Sometimes now it is called grade pay, whatever. And then dearness allowance, which is a newer concept, which is dearness allowance appropriate to the basic pay plus dearness pay at average index 536, base year 82 is 100.
Parameter.
Exactly this. So, now your lordship may just come to the rule.
Yes.
So, because it is exactly the same, I may just add one more sentence here. Yearly calculation on quantum therefore necessarily has to be the same. If our argument is accepted, then yearly calculation of quantum has to be made by the state government and yearly quantum is made by the central government. So because the formula of computing the quantum is the same, the percentage will always remain the same. Therefore, this saying that through the back door we are asking parity, that's not a correct way of putting it. There is no back door here. When the rule is implemented in the way we are propagating it should be implemented, as against their static argument, which actually is a very bright one, which has arisen right here before your lordships today for the first time after so many rounds earlier. But anyway, so if it is to be calculated as they have been doing it, they did it up to 2009, as we said it is correctly to be done, as the High Court says in the first round, which I will very briefly show a few paragraphs, and therefore the percentage will have to remain the same. It is not our saying, please give us parity. When the formula of calculation is identical, the parity has to follow with the central government on percentage. Then what is our problem? Really, our problem is the frequency. Apart from overcoming this new argument, which is now of static, the problem throughout actually in this litigation has been of frequency. The central government religiously revises it twice a year. actually, really speaking, if somebody has to have a literal operation of the rule, it must happen every month. But that's not feasible because index is revised every month. That's not feasible. So central government is doing it twice a year. The state government initially for some time did it, then started doing it once, then used to have gap years, not even once, and then ultimately a full stop. So therefore, this parity that through the back door you are claiming parity is actually an argument which is a red herring. The equation, the equivalence on quantum is on the operation of the rule. And our problem only really was on frequency. The government was not giving it because they said we have money, finance. That's what they said, which has been rejected throughout. And I'll cite one or two judgments. Now the question is on interpretation of the rule or on addressing the argument of this static argument. Now please have the rule. I have 3 points on that, my lord. Very quickly I will make them and then show those earlier orders. The rule your lordship can have from the typed version of the rule, my lord, which is at page 127.
Yes.
It's read many times, my lord. One more time. I will just read it quickly.
As many times as you want.
Because ultimately, this will what is going to decide the fate of all of us and also the state government in that way. So, dearness allowance, your lordship is not appropriate to basic pay plus pay at index average. Now, what is index average? I will not say. I am going to read 3 paragraphs of the note Mr. Diwan gave on behalf of the state government. Please have that note. Because that answers the static argument completely. That note, clause 3, 4 and 5.
Yes.
Now, please have clause 1 and 2 also I'll read all. AICPI is an abbreviation of All India Consumer Price Index. Sometimes it is also called CPI. Somewhere your lordship will see it as CPI. So AICPI is an abbreviation for All India Consumer Price Index. This index is published by the Labour Bureau Shimla, which is under the Ministry of Labour and Employment. Now, next 2 are very crucial for my argument. The Labour Bureau revises the index average twice a year on 1st January and 1st June. So therefore, index average is well known to everybody when the expression is used in a pay revision rule. And when that expression is used to calculate a dearness pay, which is a concept to offset inflation and compensate to some extent for inflationary trend, then it is the Labour Bureau revises index twice a year on 1st January. The broad purpose of this index is to enable adjustment with respect to inflation. So therefore, I say, my lord, this index average with 82 as the base year in itself is obvious to the person framing the rule and obvious to the person who is to be the beneficiary of this rule that this index average is an average which is revised from period to period, and 536 with 82 as base year, as my learned senior friend, my lord, Mr. Subramaniam showed your lordship, that is the denominator. Because when it increases, for example, if 536 becomes, say, 750, then what is to be the increase in my pay? So then, because 536 is the constant, we divide 750 by 536 and multiply by 100. That's how we take out a percentage. I mean, I had forgotten from my 10 plus 10th days, but now I have relearned it. That's how we work out the percent. What do we say? 5%, 2%, 8%. What is that figure? That figure is this index average divided by 536 multiplied by 100. So my lord, therefore they never raised this argument. It is so obvious that we are actually trying to meet a situation which on one side is so obvious and clear, and the proof of the pudding is in the eating. How have you been implementing it? You have been implementing it the way we have been saying it. What is then our problem? Our problem is the frequency of the implementation. Our problem is not that you wrongly understood it, but today, when you want to implement and you are faced with a huge amount, according to you, then you want to wriggle out of it. And therefore, this kind of an argument is now brought up by saying it is static. The submission is why I started with that judgment. Static is just opposed to the concept of dearness pay. A dearness pay can never be static. Otherwise, it is not dearness pay at all. Then it becomes a DA or a grade pay or a pay scale. Dearness pay, and it's not, I am not saying it, therefore, it is that judgment of your lordships where your lordships have explained the concept. And in the first round judgment, this is the way it has been put to grant it to us. The tribunal in the first round declined it to us, saying no right. This is the way it has been put to grant it to us. They filed a review which got rejected and the judgment became final. There was no further challenge. So, my lord, at least between them and us, they are bound by that interpretation, if nothing else. That is, according to me, my weakest submission against them, that they are bound by it. It is a submission. I am raising it that they are bound by it. But according to me, it is my weakest submission. Because the very concept of dearness pay, the very concept of index average, the very purpose of mentioning 536 with 82 base year, and the way you have worked on it, are clear pointers that you were never in doubt that it was not a constant. So, my lord, this is one which I am saying. Then, so the index average I have explained, mention of 82 by 100 is my second point. My third point is that this argument of static is abhorrent to the very concept. That's my third point. And my fourth point on this issue is that your conduct, that's my last point on this interpretation of the rule. Now, my lord, just see with me the first round judgment, because was there ever in doubt that it is not static? It is constant. That goes with the first round, my lord. Just very few paragraphs I want to read from that first round judgment. That is P25. It starts at page 368. At 369, please have page 369, para 3.1.
Yes.
Para 2, the original application was filed by the applicants before the learned tribunal seeking following reliefs. A direction upon the respondent to forthwith release 50% dearness allowance, which is due in January 2006, immediately within 1 month. Direction to immediately comply with the report and recommendations of the 5th Pay Commission. I can leave the rest. Now, please have para 3, the first part of it. The learned tribunal arrived at the following finding at the time of dismissing the application. Payment of dearness allowance to the employees of West Bengal was an absolute prerogative falling within the discretionary domain of the employer, and infraction and refusal on the part cannot result in denial of accrued right of an employee for getting dearness allowance. Though part of the recommendation of the 5th Pay Commission might have been acted upon, it did not entail that as a necessary corollary, the same had to be carried to its logical conclusion. And the third was the issue of discrimination. So the tribunal held no vested right, their discretion to grant or not to grant. Then, my lord, your lordship may have page 375. These are, your lordship may only note these paras 24, 2 and 25. The argument of the state that it is the above submission para 24 made on behalf of the petitioners and are vividly opposed by Mr. Kishore Datta, learned Advocate General. According to him, the finding of the tribunal was that claim of dearness allowance was not based on any legally enforceable right. According to him, pre-revised scale of pay employee has been transformed from band scale so-and-so. According to learned Advocate General, after an initial fixation, no formula exists for fixation of DA to the employees for subsequent period, etc. Then how the court considers it? Your lordship may come to page 377, para 31.
Yes.
Before entering into the issues involved in this petition, it will be profitable to recollect settled principles of law relating to relationship between government and its employees, public servants, right of government to get remuneration, introduction of the concept of dearness allowance to government employees, and mode of performance of function. Then, my lord, relationship between employees is discussed. I need not take your lordship's time on that. Page 379, right of government employees to get remuneration is discussed. Then, my lord, introduction of dearness allowance to the government employees starts from para 38. Kindly see the opening line of para 42. 43 is what I will rely on. 42. Dearness allowance was introduced to meet increase in cost of living, which was initially known as food allowance. It is a peculiar concept to India, Ceylon, Pakistan, Bangladesh. While dealing with the concept of dearness allowance, then Hindustan Lever is already cited on the next page, that underlined portion. Basically, the concept of dearness allowance was designed to combat inflation, to protect real wages, and therefore it should appear there should be 10% neutralization. This is a concept peculiar to India, Ceylon, Pakistan. Now, para 43 is the finding of the court that after introduction of variable dearness allowance, the allowance comes at a revisional rate at periodic intervals for the central government employees and state government employees. The change rate is calculated after taking into consideration the increase or decrease in consumer price index. This is a finding recorded after hearing both of us in a judgment which is final inter partes. Beyond this is exactly what they are now trying to resile out of. So if I can just read this para again, after introduction of variable dearness allowance, the allowance comes at a revisional rate at periodic interval for central government employee and state government employee. How can he argue today static? The change rate is calculated taking into consideration increase or decrease in consumer price index. This is exactly what we are saying. And this is the finding in a judgment inter partes and a detailed judgment. You went in review, you failed. Now, my lord, moving forward, my lord, your lordship may come to page 383. They have dealt with, my lord, para 47 regarding recommendations of the pay commission, etc. I need not read it now, my lord, your lordship would see it. Then 383, whether the claim of employees serving under the government of West Bengal for dearness allowance is a legally enforceable right. The discussion starts from para 50, 53, 54. The rules are discussed in 55. I want to refer to para 59 to your lordship. Yes. From the provisions of Rule 12 of ROPA Rules 2009, read with the contents of para 10 of the clarificatory memorandum dated February 23, 2009, and those of paras 2 and 3 of memorandum dated February 23, 2009. My learned senior Mr. Subramaniam showed both. One was general, saying that we have accepted the recommendations of the pay commission and revised in terms of 3. And the second was the variable allowance given up to 2009. In the middle, both issued, I am reading para 59, fourth line from the top, both issued by the government of West Bengal Finance Department. There is no doubt that the government of West Bengal accepted dearness allowance basically as a component of pay, which is fixed percentage of basic pay, on the recommendations of the 5th Pay Commission, dated so and so, aimed at hedging impact of inflation. Variable. These last 5 words are very crucial. Aimed at hedging the impact of inflation. The learned tribunal did not consider the issue involved in the original application from the above angle at the time of coming to the erroneous conclusion that payment of dearness allowance was an absolute prerogative falling within the discretionary domain of the employer, and action and or refusal on the part of the former cannot result in denial of DA as it is not an accrued right. So they say the tribunal was wrong to say it is their prerogative and getting DA is not an accrued right. And the conclusion after noticing those two judgments is para 65 at 388 at the bottom. Therefore, as a consequence, once the government of West Bengal accepts the recommendations of the 5th Pay Commission for payment of dearness allowance to the extent as indicated above, it confers a legally enforceable rights on the employees to get dearness allowance. So therefore, this is the conclusion which is there, my lord. Then, my lord, on one more paragraph, just kindly have para 69 at the bottom of page 389. Para 3 of the aforesaid memorandum dated February 23, para 69 at the bottom. Paragraph 3 of the aforesaid memorandum dated February 23, 2009, providing for rate of dearness allowance per month on the basic pay of an employee serving under the government of West Bengal for the purpose from April 1, 2008 and onwards, that is the extent to which the government of West Bengal accepted the recommendations till 2009, leaving the calculation for the subsequent period for its future consideration at a rate on the basis of acceptable guidelines. So it was accepted, and therefore, my lord, the writ petition is therefore allowed. The only point which is sent back is, if your lordship will see page 394, para 84.
Yes.
As a consequence, the order impugned in the writ petition stands quashed and set aside, remanding back to the tribunal for adjudication of the aforesaid two issues. One, whether the claim of employees serving under the government of West Bengal for DNS allowance at rate equivalent to the employees of the central government, and whether there is discrimination between the Bangla employees, etc. Now, my lord, this sending back, whether the claim is at a rate equivalent to the central government, also misses the crucial point that rate is nobody's discretion. The rate is the CPI index. Only frequency is the discretion. If you have to give it, you have to work the rule. The rule tells you how you have to calculate on any particular year. Therefore, the tribunal's judgment, which was read copiously, will reject it as equivalent to central government employees, but say you do it at the rate which they are getting, because the rule is identical. You have to get the same amount. So, my lord, therefore, this whole impression created as if we are getting through the back door what we can't get through the front door is completely a red herring. There are only two components of DA: the rate, whether it is fixed or variable, and the frequency, when we have to get it.
No, Mr. Yeah.
Yes.
See, let us read 84 again.
Yes. As a consequence, the order impugned in this
just on point number 1, they had decided in your favor. What is the need for them to remand?
Because the working.
That's it, working.
Yes, yes. Only on
two. Working is not to be done by CAT. Working is to be done by the government.
Let me read 82. I should have read 82 also to answer this question. In view of the discussion and observations, because that was only conclusion, the rationale is here. In view of the discussion and observations made here and above, I sum up as follows. The claim of the employees serving under the government of West Bengal for dearness allowance is based on legally enforceable right, as all employees serving under the government of West Bengal, up to such extent of recommendations of the 5th Pay Commission, which have been accepted by the government of West Bengal by virtue of provisions of Sub-Rule 1 of Rule 12 of ROPA rules, read with Para 10 of the clarificatory memorandum dated February 23, 2009, issued so-and-so, in the matter of drawal of dearness allowance in the revised pay scale issued by the government. So first finding is, employees serving under West Bengal's claim for DA is based on a legally enforceable right. That is one point which is finished.
No difference.
Second, the claim of the employees under the government of West Bengal to get DA at the rate equivalent. So that's what I'm saying. Only the rate was in issue now. At the rate equivalent to the employees of the central government requires adjudication upon consideration of the relevant material. Here I say the crucial point was missed because the central government rules were never put alongside the state government rules, and we are grateful for your lordship for asking for them. The rate is on the rules. The rule will prescribe the rate. It is nobody's discretion. Now, what is the discretion? The discretion only is whether it has to be given twice, once, or as the government says, we will not give it at all. Now, so therefore, all that was left to be adjudicated was the claim of the employees serving under the West Bengal to get DA at a rate equivalent to the employees. Only rate was in issue. And the third issue, the claim of employees serving under the government of West Bengal for Dearness allowance at rate equivalent to the employees discharging their functions in Bangla Bhavan, New Delhi, and Youth Hostel at Chennai. So we had twofold argument. After succeeding that we have a legally justifiable right to get DA, we said now my second point is I must get it at par with central government. And my alternate point is, in any case, I must get it because my Bangla colleagues working in those two bhavans are also getting it. Now the tribunal rejects both these points, does not grant either. But what does the tribunal say? Tribunal says you work it out. But the working, what I am submitting before your lordship is, the flexibility in working is not there. It has to be as per the rule. The rule gives the formula. And because the central government rule is the same and my rule is the same, necessarily the conclusion has to be the same. When we divide the API index by 536 and multiply it by 100, whether the state government does it or the central government does it, the answer remains the same.
Can you read now para 84?
Yes. As a consequence, the order impugned in the writ petition stands quashed and set aside, remanding the matter back to the tribunal for adjudication of the aforesaid two issues, namely one.
Two
issues.
Namely,
whether the claim of employees serving under the government of West Bengal for Dearness allowance at a rate equivalent to employees of central government, and two, whether discrimination in the matter of pay of Dearness allowance to employees of West Bengal with their counterparts serving in Bangla Bhavan and Youth Hostel, Chennai, on merits without being influenced by the other. So, my lord, the current division bench, which has been read before your lordship, also crystallizes this position that our right to get it has already been finalized, and I am not touching that judgment. That is final. All that I am now going to discuss is the second 2 points, whether we are to get it at par with the central government at the rate of the central government, and second, that Bangla Bhavan. Now, my lord, the CAT. All right. Now, my lord, kindly see the judgment of the tribunal in this round. It starts at page 462. Just kindly come to first page 476, where the discussion starts. Just 2 paras here also, not much.
Yes.
Page? Page 476. Yes. Now, my lord, I will be brief, my lord. I'll give the paras in a written note, but I just want to read 2 paras. Now, we would like to consider the first issue, whether employees of government of West Bengal are entitled to get DA at the rate employees of central government. Now, this is the first issue. Now, para 26 in this is very, very crucial. At page 477, because there are some admissions recorded of the government council by the tribunal. Now, just kindly see that at para 26.
Yes.
The question crops in our mind, what norms or principles were adopted by the state government for, I'm sorry, yes, she was noting I started.
Yes, continue.
All the para 26. The question crops in our mind, what norms or principles were adopted by the state government for payment of DA along with basic pay in the revised pay structure in terms of ROPA Rules 2009. The admitted position is that the state government has released DA at 125% of basic pay with effect from January 1, 19. On our specific query to Mr. Basu, he was the government counsel member,
yes,
as to what norms, principles were followed by the state government for payment of DA to its employees, he has categorically submitted that the state government has released installments of DA for its employees on ad hoc basis depending on financial capacity of the state government. Now, these installments of DA which were being released on every year were not the same. They were enhanced installments. That chart is given at the bottom, 2, 6, 9, 12, 16%. So this static business is nowhere in the picture. This has only come now, because, so my lord, I mean, so what norms and principles were followed by the state, he has categorically submitted that the state government release installment of DA for its employees on ad hoc basis, depending on financial capacity of the state. Similarly, on our specific query to Mr. Basu, what pattern was followed by the state government for release of DA at 16% of basic pay from April 1, 2009, he has fairly submitted state government has followed the pattern of the central government for release of DA. But here comes my submission that the pattern has to remain the same, because the calculation of percentage is the same in both the rules. He has fairly submitted that the state government has followed the pattern of the central government for release of installment of DA. The installment of DA released by the state government for its employees from 1st January, so and so, and central government can be shown in the following table. Now please see para 27, first line. There is no doubt that payment of DA to the government employees stems from the need to protect the erosion in the real value of basic salary on account of inflation in the market. Naturally, DA admissible to government employees correlated to the level of inflation. Then the last line of this para, be that as it may, fourth last from the end. The government of West Bengal has released DA from time to time by following the pattern of release of DA by the central government, though the state government has released installment at different rates and from subsequent dates after release of DA by the central government. So, my lord, what I am trying to make out of this is, it was never static. When they released it, they knew it has to be linked to the price index. That is how it was being released. But the frequency was erratic, and that was our problem. So therefore, my lord, sometimes they would change the frequency also because the government kept on going up gradually. So the government DA kept on increasing, but they sometimes gave less increase, because if you don't do it at a regular frequency and you give gaps, then that leeway to go up and down accrues, because you have not reached that level of the central government. Then after 10 years, suddenly they gave 125, which the central government is giving for the last 10 years. But that doesn't solve our problem, because if we don't get it for 9 years in a gradual increase and only get the increased one for 1 year, that's hardly a small percent. Our gap is for those 9 years we haven't got. And therefore, that is what the tribunal says at page 482, para 30 and 484, para 34.
But the remand was only for rate, not about frequency.
But
the High Court says, read again the operative part of the High Court order when it was
yes. So rate will include the frequency, my lord, is my submission. The rate, if the rate, central government, if the rate has to be.
You said that the real problem is frequency, not the rate.
Correct.
But the High Court, while remitting back, says rate.
Correct.
Not about frequency.
No, rate of central government, parity. The remand was on parity.
Yes.
Rate of central, the word uses rate of para 84.
Not parity on frequency.
No, but
parity on rate.
No, rate will include frequency also, both. Because central government gives twice a year.
How you are changing the goal?
No, I'm not. If we get parity with the central government, both accrue to us. Whatever central government gives has to accrue to us. So, and even otherwise, my lord, the point I'm trying to make is that when your lordship looks at what is dearness allowance, what is the purpose of dearness allowance, any interpretation which your lordship gives has to be consistent to achieve that purpose. If the purpose is to defeat inflation, then at least this static will not come in. And if it is linked to a consumer price index, which is being modified and improved on a yearly basis, then necessarily yearly basis is the intention. As your lordship said, this is about the rights of an employee. In this case, financial resources, what your lordship wants to do, whether you can, assuming I am to succeed, there are two judgments, my lord, I'll cite those paragraphs and leave it there, where your lordships have said that when we are considering financial constraints, when we are considering financial constraints for an industrial employer, or we consider financial constraints for a body or a corporation under Article 12, or we consider financial constraints for a state or central government itself, our parameters are slightly different. Because central government has power to generate revenue. An industrial employer or a state under Article 12 may not have capacity to generate the revenue. So therefore, your lordships have said, for central government, the financial argument is normally not an argument which your lordship easily accept. And in cases your lordship have said, it can be in installments, the payments. That we are open to that also. I will cite those judgments, my lord, in a small written note for your lordships. But what?
Yes.
Yes, just kindly have this table at 478. Yeah, I'm coming. Just get a password.
I was only, we were having a small discussion, nothing to do with this.
No, that's very healthy, my lord.
So I was telling my lord that depends on state to state. You said that states don't have money. Lord comes from a state where there's surplus money. Jharkhand, you said surplus money.
Correct.
Not surplus, but comfortable.
But I was saying that
Himachal is not comfortable.
Both of being a first generation state, 76% of the budget of the annual budget goes towards salaries.
Correct. Even that way, Himachal is, I think, deficit at the moment, and so is the state I come from, which is very unfortunate that Punjab is deficit, but that's how it is. Now, if your lordship will see, the problem is only, just see this table also which they gave.
Yes.
Now, just see this table at 78. The rate 2% is given by the central government in July 6. State government gives it in April 4. Then when they revise it, they don't revise it for almost 1 year. And the rate is 6, but the state government gives it in June 8, central government in January 7. Then again, when the revision takes place, central government does it in November 8. Here they have done it earlier. Then 12, 9, state gives it in 8. So they are lagging behind. And then they completely stop. It becomes blank. So therefore, my lord, therefore ultimately the submission is, my lord, that in fact the ACPI index is built in. Static is an argument is not valid. And ultimately in the first round, the finding that we are to get it and that it is cannot be static and it is correlated to the ACPI index is already there. Now, my lord, one document which we have been able to get, my learned friend can verify that document. That is a Finance Department Audit Branch Memorandum. Just give it to them. Now, they have got it over lunch, my lord. It has some blanks. So I'm cautiously giving it to your lordships. With that caveat, it's been downloaded from their website. But what I just want to show is, just see page 3, clause 8, pensionary benefits is the title.
Yes.
Then come to page 4. Dearness relief up to AICPI average index 536. So the lordship said, is there some document where AICP is mentioned by them? So then this is the result of that research. From their website, we have downloaded. So this is subject to, my lord, Mr. Sibal seeing it and verifying this. So I am very grateful, my lord, for the. Yes.
Thank you, Mr.
I am grateful. Can I be excused for 10 minutes?
Most certainly, most certainly.
May it please your lordship, Lord, I had the privilege to be there before the High Court and the Tribunal to argue the matter.
Of course, we are Jiddan neutral, but the lady said that she would be arguing first.
No, but in fact, I ought to move the case.
My lord, he had made a special request and I said.
I have been considering to the request of others and getting bogged down. Anyway.
We only thought that you would have at the last,
No, I have to read, I have been staying here for the last 3 days. Now, the first petition was moved before the tribunal, seeking basically two relief, that our employees posted at Chennai and Bangabhavan, Delhi are getting TA at the central rate. We are not getting it. The government is delaying in payment vis-a-vis the payment time scheduled by the central government, therefore let it be released. And the petition was dismissed by the learned tribunal, holding that DA is only a discretion by the government, you have no right. But from that petition first came before the High Court, that division bench of the High Court to decide that no, this is a legally enforceable right. I will not repeat what you have seen that judgment, I should place that part. And so for the other parts concerned, then court directed that following L. Chandra Kumar, those issues should first be decided by the tribunal. Therefore, the tribunal will now decide whether the payment of DA at the rate of central government to a section of the government employees because of their postings at different places would be justified, and whether the non-payment of DA keeping in the time schedule or period released by the central government is justified. Now, the Honorable Tribunal thereafter, in fact, wanted to know from the State Council how they would really interpret their own rules. Now, in the background thereof, I will just invite my kind attention to the rules. If I may place, the rules are not very important.
Yes.
Kindly turn to page 126.
Yes.
And this 126 is preceded by the recommendation of the Pay Commission, that is at page 97, though it was referred to, I am not taking my leave to refer it once again.
Yes.
Page 97, this is the annexure of the Pay Commission.
Page
97.
Yes.
We'll kindly come to paragraph 10.2.
Now we first deal
with dearness allowance.
Yes.
Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by Pay Commission, so and so, then the state government since 1st April 79, can note this, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of dearness allowance. But almost invariably there is a time lag in actual payment, and when the same is paid, the same does not include any arrears. Right now, only one such installment has remained due, which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from March 2009, was sanctioned by the Government of India on January 2008. A major grievance of most of the associations of the employees has been non-payment of the DA installments in time. Now, this is the basic grievance which is still we are pursuing before the court. As per the Government of India's announced policy, this is payable twice a year, namely with effect from 1st January and 1st July each. As per information available, a chart is given. I am not troubling my lord with that. Then kindly will not turn to 10.6. It is evident from above that a state government sanction of the installment does not follow any definite pattern. It is also clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the Government of India with effect from July 2008, then fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. It is done, it will mitigate a long-standing grievance. This recommendation of pay commission was accepted.
Yes.
And without, then the rules were promulgated under 309.
Right.
Now, kindly come to without page 162.
Yes.
This is the memorandum dated 23rd February 2009. This is in clarificatory memorandum with the West Bengal Service Rules 2009. 2009 rules that I shall come to your lordship.
Yes.
But kindly now come to next page. After clause 5.
Yes.
To make recommendation each of the clause 5E, to make recommendation each of the above having regard internally to the prevailing pay structure under the central government, public sector undertakings and other state governments, etc., the economic conditions of the country, financial responsibility to the Government of India and the pattern of allocation of revenues to the state, the resources of the state government and the demands thereon on account of the commitment of the state government to development activities. The Commission submitted its report on 12 February 2009. After due consideration of the recommendations of the Commission, the Governor has been pleased to make the decisions set out in the following paragraphs. That I emphasize it show that when government appreciated the financial responsibility, having appreciated that, took this recommendation into acceptance and issued rules. Then kindly come to page 166.
Yes.
166 is also very important. This is the continuation of the memorandum, which starts at the very same memorandum, 23rd February 2009, and kindly come to clause 10 at page 166.
Yes.
Consequent upon revision of pay of government employees in accordance with the West Bengal Division of Pay Rules 2009, the Dearness allowance to which a government employee is entitled from time to time since the first day of January 2006 needs to be related to pay in the revised pay structure. Necessary government order in this regard has been issued with Finance Department memo dated so and so. Then this itself indicates that the government was very much concerned about the payment of DA periodically in terms of or in the pattern followed by the central government. Kindly now come to the rules at 126.
Yes.
By the way, kindly notice the 23rd February 2009 is a very remarkable date. All these notifications are issued on the very same date. That will indicate how the government had appreciated and how the government wanted to implement. Now this rule at 126, kindly come to page 127.
Oh, can you just repeat that again?
This 23rd February 2009, when the ROPA Rules 2009 is promulgated, on the very same day, the clarificatory notice comes. The clarification says that I have placed that they have to follow the pattern and they have to fix up in terms of the rules 2009, which is at page 126.
Can you just take us to the notification again?
166. This starts at 162.
The local notification is dated
23rd February 2009.
3rd February 2009.
And this clarification is on 23rd February 2009.
Page
162. And another clarificatory notification is at page 168. There, they show the chart how it is to be followed.
Yes. Yes.
Therefore, these three, the rules and these memorandums have to be read together to find out the intention and the decision of the government vis-a-vis payment of dearness allowance.
Yes.
Now, again, I will not come back to page 126 and the relevant portion at page 127.
Yes.
Where Lordship will straightway come to sub-rule C of Rule 3.
Yes.
Existing emoluments being the aggregate of existing basic pay, dearness pay appropriate to the basic pay, and 4, dearness allowance appropriate to the basic pay.
Yes.
Plus dearness pay at index average 536.
Yes.
Because the base being 1982 equal to 100. Well, this 536 was arrived at by the Consumer Price Index Authority as of December 2005. Why 2005? Because these rules are being effective from January 2006. Therefore, the immediate available data of price index, that was 536, which is the base.
Right.
Subsequently, with the variation, nobody can say that the cost of price index will remain unchanged, unaltered.
Yes.
Then the concept of DA would go. DA is only for the purpose of mitigating the situation of price rise.
Yes.
Therefore, when the rule is given effective from 1st January 2006, the available cost of price index was 536, taking 1982 as the base as 100.
Yes.
Therefore, the basket which was available at the rupees 100 at 1982 is the basis, and on 2006 it is 536 rupees.
Yes.
Now with the change of DA, you have to change it, and that is your own notification. No question of static. 536 is completely static. It cannot be moved. That is, in my humble misconception of the situation and the law. Now, this memorandums will be read together. The High Court finds that this is an enforceable right, which has reached its finality. I am not going to argue on that. Then the matter is sent back to Tribunal. Now, Lordship kindly take the Tribunal's order,
yes,
which is very important. Because that is volume 2, page 428.
Yes.
Sorry, but it starts from page 463. But just for Lordship's information, the first division bench judgment which has held that this is enforceable right, but they did not prefer a bill, they preferred a review.
Correct.
The review was dismissed, and then they went back to the tribunal accepting the judgment, filed their affidavit and contested on merit whether we are entitled to the DA at the same cycle and rate by the central government or not.
Very good.
Here, Lordship kindly turn to.
No, cycle word is not mentioned.
Pardon?
Cycle word is not mentioned
No,
in the High Court remand order.
Not.
It is only rate which is mentioned.
The remand is only without sending back the original application.
And this there was no cycle prayer.
No.
In your original application preferred before the tribunal at the inception.
My prayer was with the original application that release at the same rate.
Rate, not cycle.
Same rate means yes, same. So kindly comes to my prayer is also, if your Lordship takes up my prayer B.
Come. High Court
258. The High Court
order, High Court has noted
No, High Court has only sent back the matter.
368.
368, yes.
368.
My lord. This is the division bench judgment.
Yes.
No, Lord, before Lord Lordship.
Just
368, that is reproduced.
Also leave.
Okay.
Please show that what events are not please upload all. We have a practice here that our orders must be uploaded within 24 hours. That's the practice which this court follows.
Oh, that's wonderful.
Every order has to be uploaded within 24 hours. Therefore, we are telling his leave and upload it.
That's really.
Because this court already uploaded.
This is
within 24 hours.
helpful for all of us. Someone kindly takes the trouble to come to prayers quoted in the.
She's reluctant because it's not the norm here. She should leave the court.
Well, at page 369, kindly see whether the original application prayer supported. 369. This is the first division judgment which has.
No, we were quite doubtful. In fact, we put it to Mr. Patwalia, but couldn't get the answer. If the High Court had decided everything, it's not the end. That's how we may have committed a mistake.
Sorry.
Reading it, if the High Court had decided everything, then what was the occasion for the High Court to remand the matter, and more so, para 84. And that's what is called.
Well, may I just tell your lordship why High Court remanded it?
We only want to know page, what is the import of para.
I will take a lordship. I will take a lordship. The kindly sees below my prayer which was there original application.
Continue. Sorry, we didn't
No, para 2, a direction upon the responding authorities. Para, that's at page 369. 369.
Since it is your baby, we thought, you are the best person to answer.
Yes, that's true.
Yes.
But a direction upon the respondents' authorities to forthwith release the 50% Dearness allowance which was due up to January 2006 immediately. That is inherent. And then a direction upon the respondent to immediately comply with the report and recommendation of the Fifth Pay Commission positively and without fail within a period of 1 month from the communication. But the Fifth Pay Commission says that, and when I say that pay 50% of the allowance which is due, that comes due vis-a-vis then direction of respondents to release the 50% of Dearness allowance as the state government without releasing the 50% Dearness allowance for mere eyewash. Set up a Sixth Pay Commission is not important, my lord. Therefore, these were the prayers. What the division bench has done after having coming to the conclusion that this is not only a discretion of the state, this is an enforceable right. Then kindly come to the why the High Court remanded it. Kindly come to the page 82.
Yes.
No, before that, may I just take the other part? Kindly come to the page 391.
Yes.
Paragraph 76. Sorry, that I probably have missed. Yes, paragraph 52.
Paragraph 52.
Sorry, 52, 385. After considering, I got it.
Yes.
After considering the above report of ROPA 2009 was framed in exercise of power conferred by the so-and-so, therefore it is evident that the Dearness allowance was also one of the components which came under the purview of his considering the rolling out of Fifth Pay Commission. Sub-rule 1 of Rule 12 of ROPA provided that no arrears of pay which government employee might be entitled in respect to the period from January 6 to March 2008, that this is the reflection of government's consideration of financial liability. Therefore, they said that this part you are not getting should be paid to the government employees. Needless to point out that the above decision included non-payment of area Dearness allowance for the period. The government of West Bengal Finance Department Audit Branch that I have placed this, I have not submitted my lot it again. Then kindly come to paragraph 59, which Mr. Patwali has placed. I have not taken trouble my lot with that. Yes. Then kindly come to 68.
Yes.
Under sub-rule 1 of Rule 12 of the ROPA, it was declared that no arrears of pay to which government employee might be entitled in respect of so and so. I have already found that paragraph 10 of the clarificatory memorandum, February 23, 2009, and on allied matters provided that the Dearness allowance to which the employee serving under the government of West Bengal was entitled from time to time. But this rules out the perception of stagnancy. 1st of January needed to be related to pay in revised pay structure in this regard. This was the finding. Then 76.
Yes.
Further, the factors which were taken into consideration by the central government in fixing the rate of Dearness allowance for its employees were required to be taken into consideration with those taken into consideration by the government of West Bengal. In the event the factors were common and same for both governments, then the element of arbitrariness were required to be examined in the context. These are all on the basis then why it was remanded. We kindly come to Milord paragraph 82.
Yes.
The claim of the employees serving under the government of West Bengal is based on legally enforceable right on all the employees serving under the government of West Bengal up to such extent recommendation of Fifth Pay Commission which has been accepted by the government by ROPA rules. Then finance department so and so. The claim of the employees serving under the government of West Bengal to get Dearness allowance at a rate equivalent to that of the employees of the central government requires adjudication upon consideration of the relevant materials on record for the purpose indicated here and above. The claim of the employees serving under the government of West Bengal for Dearness allowance at a rate equivalent to that of the employees discharging their function in Bongo Bhavan at New Delhi and Youth Hostel in Chennai requires consideration of the materials which may be brought on record by the government of West Bengal. The aforesaid second and third issues, namely whether the claim of the employees serving under the government of West Bengal for Dearness allowance at a rate equivalent to that of the employees central government, whether the discrimination in the matter payment of Dearness allowance at the employees of state of West Bengal so and so, then court cannot be done in this seat application. As a court of first instance, in view of the principles of law settled in the matter of L. Chandrakumar, the learned tribunal is the appropriate forum to discharge the above function as a court of first instance. That's why it was demanded that only the issue which was decided by the tribunal rejecting the OA, holding that you are not entitled to, that issue was not considered, other issue was not considered by the High Court and said, go before the tribunal and get it decided. Therefore, the High Court had no more occasion to go into the other issues because those issues were not then yet decided by the learned tribunal. To the final judgment of the tribunal.
Yes.
Which has been was taken to the High Court, or the High Court but refused it, refused it.
Yes.
Then now it's before Lordship. Now kindly turn to the paragraph 28. Since the other issues which have been dealt with here have been repeatedly argued, I am just avoiding.
Yes.
I am straightway coming to paragraph 28.
Yes.
Since we have to examine whether the employees serving under the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government, we need to first understand what are the issues and processes involved in payment of DA to the government employees. And the memorandum issued for payment of DA and revision of DA, February 23, 2009, which I have only placed before Lordship, we find the following similarities and differences in payment of DA to the state government employees as compared to the central government employees. DA has been paid as a percentage of the basic pay, not on the full package for both central government employees and the state government employees. Both the central government in terms of 6th Central Pay Commission and the state government in terms of 5th State Pay Commission have used AICPI 1982 being 100 for industrial workers for measurement of inflation. This is very important. When the AICPI does not determine the DA, it determines the inflation on the basis of which the DA has to be determined by the respective governments. Therefore, AICPI is the basic norm. The base AICPI for calculation of DA with effect from January 2006, when DA has been considered as zero, has been the AICPI of 536 as per 1982 series, which has been same for the central government employees under 6th Pay Commission and the state government employees under 5th Pay Commission. In fixing the initial basic pay in the revised pay structure, as on January 1, 2006, the same AICPI has been used by both center and the state.
Continue.
Yes. Then in case of central government employees, it has been specifically mentioned in the notification that the inflation neutralization will be 100%, meaning thereby.
Continue, sir. Yes, just.
Yes.
Here with you.
Now will be 100%, meaning thereby the DA percentage increase will be same as the percentage increase in the ICPI. But this is the finding of the tribunal itself. In case the state government employees, it has not been specifically mentioned that inflation neutralization will be 100%, but the pattern of payment of DA in the initial years till 2010 indicates that the state government has also followed the same principle. Therefore, up to 2010, the state government followed the central government method blindly. 2011, with the change of dispensation, all these variations comes into operation. Now, it has been notified by the central government while accepting the recommendation of 6th Pay Commission that DA will be sanctioned twice in a year, January and July. This has not been clearly spelled out by the state government by any notification. Though on scrutiny of notifications, we find that while in the initial years till 2010, payment of DA was made twice in a year. But after 2010, the state government has not followed this pattern. The practice of revision of DA on January and July is done by the central government. The central government has notified that the revised DA on January and July will be payable with the salary of March and September respectively. This timely payment of DA has guaranteed compensation. Kindly underline these things, which is very important for the purpose of fixing DA. Guaranteed compensation for erosion of basic salary within a reasonable period of time. In case of the state government, there is no such notification and no such principles have been followed, and there has been a long delay in protecting the erosion. This is the basic consideration. Now, comparison of payment of DA by the central government to its employees and by the state government to its employees, we find that the principles followed by the state government in terms of relationship between DA and the basic pay, use of AICPI as a measure of inflation, relationship between DA and ICPI and computation of DA are the same as that of the central government.
Yes.
The state government has followed the same principle for computation and payment of DA on basic pay fixed under 5th State Pay Commission, as has been done by the Central 6th Pay Commission. The Central has revised DA twice in a year, January and July, on which DA is payable, where the state government initially paid twice in a year, but discontinued to pay twice in a year after the year 2010, and has delayed payments of DA without following any principle in an arbitrary manner.
Yes.
Therefore, that this delay of release, if that is taken care of, I think the demands of the employees will be met. This is the grievance which the tribunal finds this is arbitrary.
Yes.
Division bench of the High Court has observed that Dearness allowance is a legally enforceable right of the state government employees, which means that the state government employees have the right to be compensated for the erosion of their basic salary due to inflation. If the real value of basic pay decreases due to inflation, then the state government employees have the right to be compensated. And if such compensation is not given effect within a period of reasonable time, then their right to get compensated is infringed. inflation changes with time, and thus the period of time within which the employees are to be compensated is extremely important. And as such, the right to get DA within reasonable period of time is an integral part of legally enforceable right.
You cannot read
This,
now can you come to page para 33?
Well, yes, I was going to show that.
33.
31, Lordship probably have noticed. Can you
Exactly, para 33. And that's what everyone has read, both the sides have read.
Yes, we have read 33. I am at 33. We have already observed that there is no mandate, either under the statutory rule, namely ROPA 2009, or in the administrative directions issued by the state government in the form of memorandum, taken so and so, which are placed before Lordship. Now, in the absence of any mandate under the statutory rules or the administrative direction, we are unable to hold that the state government employees are entitled to get DA at a rate payable to its employees by the central government. However, from the discussions made by us here in what we can hold without hesitation, that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published. It is a bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of ROPA 2009.
We request you to please focus on this. First, also Mr. Patwale has said how AICPI is applicable. Would you like to add something more to that? Is what we are asking.
No, I would not be adding lot to pardon the Honorable Court time and without patience. What I am saying,
we are very patient.
No, I feel that.
We have
But as a counsel, it's my duty to feel also what is correct.
But what we are saying,
Therefore,
core issue.
Yes, core issue.
Whether AICPI is applicable or not, this is a core issue.
No, it's applicable, no doubt.
The finding of the tribunal, what is the finding of the High Court, is what we have to now consider. So therefore, in in addition to what the courts have read and what has been argued, is there anything else which you wish?
No, Lord, at the moment, Lord, I have nothing to say except that kindly come to 34. It's very important.
34, yes. Let's see.
Okay, say it also. Now kindly come to 34. Next issue. For our consideration, whether the payment of DA to the employees of state government at Bangalore, New Delhi and the youth hostel in Chennai at the rate payable to the employees of central government and payment of DA to other state government employees working within the state of West Bengal at a different rate is discriminatory. The admitted position is that the state government employees working at Bangalore.
But Mr. Diwan said that he is not challenging.
So, therefore, the fact remains, Lord, today after this order, they say we have accepted this. The fact remains, Lord, so far the DA is concerned to the state government employees, some was getting at the central level. Therefore, you do not dispute and deny, I am on that. That the payment of DA at the central method was acceptable to you. And that's why you have paid to some of the employees.
Yes.
Now we have to, the tribunal says that there is no statutory mandate, but at the same time, tribunal says you have to evolve the method.
Yes.
To evolve the method for payment so that there is no erosion of the issue of payment of Dearness allowance. But today price rise is indexed, it is rising. Now I am paid 2 years thereafter. In the meantime, further price rise. How would the employee cope up with that? Therefore, you are in fact frustrating the basic purpose of DA.
Well,
these are the basic things on which I would like to emphasize upon. Therefore, the question of applicability of the AICPI is not under doubt. And the change of the pattern of payment up to 2010, the government followed the same. If the government did not have any doubt that this should be followed. 2011 after, you have departed by not paying on time. Therefore, the payment of DA is not under dispute. The dispute is payment on time. Now, as I said, when you accept the Pay Commission's recommendation, you accept with the financial responsibility and liability. You know this. That's why you say you did not pay me the area from 2006 to 2008. That is a part of conditional acceptance of the recommendation. Therefore, subsequent thereto, You know that this is my financial liability. Now, you cannot just turn around and say, no, I don't have any finance. But though the finance is not there or not, but that is, they have the difference in the confidential petition before the High Court. The High Court must decide whether genuinely they have any difficulty or not. Now, the question of the finance, I just deny one judgment and then let's stop. This is not 2022, Volume 4 Supreme Court cases, page 363.
So, cognitive financial difficulty cannot be in the stop.
Yes. Paragraph 57 particularly.
Yeah.
Therefore, the defense of the state, the argument which was sought to be developed as a new argument, it was never argued before the Tribunal or before the High Court. And the idea that DA Millard gets stagnated on 536 to deepest of restraint is totally creation out of blue without having any foundation. My juniors do not insist me to believe that
even according to them, it is not static. It is swinging, but not the way you want it to.
No, that obviously is other difference. If they accept the way I want, there is no question of the litigation. But they have to be reasonable. If they say, I do not accept you 100%, I have a reasonable way of doing it. State will not, in no way can not. Paragraph 38 at page 482. Yes.
Paragraph 38.
Well, kindly come to this. Yes, I have also marked it, but slipped it. I'm reading on for what norms or principles have been followed by the state government for release of DA for its employees. No satisfactory answer in this regard came from Mr. Basu, the learned counsel representing the state.
Yes.
Mr. Basu merely tried to impress upon us that state government has following the pattern of the central government have admitted. Following the pattern of central government releasing DA to its employees, but the state government could not pay DA.
Which page you are
reading? Page 482, paragraph 30 of the Tribunal. That's judgment.
We thought you are reading this judgment which you have.
No. After without placing the judgment, juniors are prompting me that.
38 you are reading this. The function of the pleading is?
Paragraph 30, page 482.
We have read it. Don't worry.
I was reading them, it was read. So that's all. But I hope not your lordship will be pleased to.
Next.
Yes, please, may I take leave?
Most certainly. In the phone voyage.
I was stuck up here for the last 3 days.
My lords, today, after Mandavar, we have the Constitution of India. And under Article 309, the requirement is for the rules to contain the schema to calculate employment terms, for everything to flow from the rules. And why is this, my lords? This is because the Constitution is the bulwark of state government employees, central government employees, industrial employees against arbitrariness.
Yes.
So therefore, my lords, the ambit of the disagreement between us is what do those rules mean? When they cite the All India Consumer Price Index, what do they mean? My lords, my learned senior Mr. Subramaniam has been kind enough to give me this report. Which we will hand over. It's the annual report, my lords, of 2010, issued by the Ministry of Labour and Employment on the Consumer Price Index. My lords have it.
Yes. I could not comprehend your submission. That after Mandava we have the constitution. I somehow missed it out.
My lords, Mandava referred to a set of fundamental rules that was pre-constitutional.
But nonetheless, when the constitution was there, and anyhow, okay.
My lords, I will also come to Mandava and satisfy my lords. Essentially, very briefly, the rule in Mandava, my lords, Rule 44 of the fundamental rules, is the rule that granted discretion to the state governments. Now, our rule, what it does is that pursuant to the discretion, it records a commitment by the state government to follow 536 brackets 1982.
So you
beginning at
Mandava may or may not apply. Mandava was anyhow. That's all right. We have understood what it is. Yes.
I'll also come to Mandava, my lords, and attempt to satisfy them. My lords have the folded portion in the report.
Yes.
Page 3, which is the preface, it says, the consumer price index numbers for industrial workers are being compiled, maintained, and disseminated by the Labour Bureau since its inception in October 1946. These index numbers, apart from being utilized for fixation and revision of wages, determination of variable Dearness allowances, and this is important, my lords, that this is a prime reason why this is compiled in the first place.
Yes.
Are also utilized as an indicator for measuring inflationary trend in the country and for policy formulations. These index numbers are compiled by the Bureau on month-to-month basis and are disseminated through press release, monthly index letters, Indian Labour Journal and website. Despite regular dissemination of these index numbers through various forms of media, there has been a growing demand over the years from users for more detailed serial data vis-a-vis what is, I beg your pardon.
Yes, yes.
What is published through the ILJ and other publications of the Bureau. Labour Bureau, accordingly, for the first time in 1997, brought out an annual report on consumer price index numbers for industrial workers, containing details of all India and centre-wise indices for the year 1996, which was well appreciated by the users. Now, my lords, they then thank shopkeepers, but what I want to point out is that I take this opportunity to express my gratitude to all the selected shopkeepers of the selected markets in 78 selected centres who are furnishing price data on voluntary basis. Now, my lords, these 78 centres will include rural Uttar Pradesh, rural West Bengal, Calcutta, Park Street, it's expensive even for me sometimes, my lords, South Delhi, other parts of Delhi that are less expensive, Bongo Bhavan is in Delhi, Chennai, which has variable rates in terms of prices depending on locality. But this, my lords, is the all India index. So, my lords, why would the state of West Bengal adopt an all India index? And that is because yes, my lords, I'm just coming to the point at which they explain that earlier.
Just one minute.
Do my lords, will my lords be kind enough to come to page 34 of this report? This is not the folded part, this is now the next one.
Yes.
My lords have it?
The Indian scenario?
My lords, yes, I'm on para 4.2, which is the second paragraph.
Correct. The compilation of index numbers.
The compilation of index numbers in the country dates back to the period immediately following the First World War. The sharp rise in the prices focused the attention of several provincial governments on the problem of rising cost of living. As a result, some provincial governments started conducting family budget inquiries and compilation of consumer price index numbers for some cities in the country. As none of these index numbers were satisfactory, the job of compilation of consumer price index numbers was entrusted to the Labour Bureau, this is the one in Simla, earlier known as the Cost of Living Directorate, on the recommendations made by the Rao Court of Inquiry in 1943. The Labour Bureau launched Family Living Survey during 1958 to 59 in 50 important industrial centres all over the country on uniform and scientific lines laid down by the Technical Advisory Committee on Cost of Living Index numbers. Based on the results of the survey and utilizing the retail prices regularly collected from the selected markets, the Consumer Price Index numbers for industrial workers on base 1960 for each of the 50 centres in all India had been compiled and published by the Labour Bureau. Amongst all the available CPI series compiled at the national level, the CPI series for the industrial workers is the most popular, as also talked about series, as the Dearness allowance of the industrial workers, as also of all salaried employees in public and private sectors, in services and trade, etc., is regulated on the basis of average all India centre-specific CPI series for industrial workers. Even central pay commissions in the past used CPI for industrial workers than the CPI series for urban non-manual employees, for regulation of salaries and allowance of central government employees, including public sector employees and the armed forces.
Yes.
Now, my lords, I'll just point out for my lord's satisfaction that in the folded portion, page 15,
yes,
in the first column, 2005, it mentions our 536, which was adopted in the rules, in the ROPA rules.
Yes.
And my lords, this was the reason I began with this was that it had fallen from my lords that where does the how does the index connect to Dearness allowance? And the main purpose for which the index is compiled based on that basket of goods that the average working family uses is to calculate Dearness allowance.
Okay.
Now, my lords, the calculation of Dearness allowance, and I won't go into the formula which my learned friends before me have placed, but the formula is quite clear that you use the base AICPI and then you use the current inflation rate. And based on the two, then you come up with a number. Now, if you have the base CPI, there is nothing from them to say how their 2%, 6%, 16%, 125%, how it's calculated. And my lords, the only way in which you can use this base number is by using a number that is an all India number, based on the same basket of goods.
Okay.
Because otherwise it would be meaningless. So there are, for example, other states that have not adopted the AICPI. For example, we have the state of Kerala. So what does the state of Kerala do? And this is in my compilation.
Yes.
My lords, at page 83, page 80, I beg your pardon.
Yes.
This is the Kerala Department of Economics and Statistics, the Consumer Price Index number for agricultural laborers and industrial workers for the month of April 2025. VDA also dated 31st August 2013 of the Labour and Skills Department, Government of Kerala, and the so-and-so MS or government order dated 2015, published in the Kerala Gazette. They have, my lords, these various centers, and they have compiled their own consumer price index based on 17 centers.
Okay.
So they don't make reference to the AICPI. They use their own. No problem. Because under Article 309, all it says
Can you just read page 80 again?
Yes, please. My lord, Mr. have page 80. So, my lords, this is from the Department of Economics and Statistics of the Government of Kerala.
Something about Government of Kerala.
This is the Government of Kerala, my lord. My lords, I'm just giving an example of another state that does not wish to use the AICPI.
We are not. Kerala is also not using AICPI.
Kerala is not using AICPI, my lords. West Bengal is using AICPI in their rules, but not in practice. Kerala, my lords, has disavowed AICPI because what they have done is that they have evolved their own mechanism, and they have 17 centers from which they determine their own Kerala Consumer Price Index for agricultural laborers and industrial workers. So they don't have rules where they reference the central government.
Is there any such price index specific for West Bengal?
I beg your pardon, my lord.
Is there any specific price index which is specific to West Bengal, like
my lords, I appreciate what has fallen from my lords. There is not.
Yes.
So, my lords, therefore, we have a situation where Mr. Diwan's argument, brilliant though it is.
Mr. Subramaniam, where do we find that which index, like if Kerala is using such state-specific index, so where is that enabling provision as to which index will be used, whether state-specific index or AICPI, or you may choose whatever you like.
Well, actually, what one does is that AICPI is a very reliable form of gauging inflation.
No,
because I'll tell you, no.
We are not about reliable.
Yes.
Where is the legal sanction or absence of sanction for use of a particular index?
Well, the legal sanction.
Yes.
Yeah.
If they are using their own index, something like that,
yes,
or if they are not adhering to AICPI, they must be calculating on the basis of some index, because rule says average index.
No, that's the perfect.
What
perfect
that?
Yeah, well, I'm grateful. That's the perfect question your lordships asked. What is that index which you have used?
Which they are using.
That's the point. Well, there is no index apart from this. There is nothing like a. As I said, there's nothing like a Mahalanobis formula. That's why they've not done that. That is the whole point. So, in the absence of any specific index specific to West Bengal, which has been formulated by them through rational criteria or through any scientific study, they are relying only on this AICPI, that is 536.
536 is the pointer.
536 is the point. They are not adhering to it. Therefore,
they are not adhering.
That's the point. And therefore, it is arbitrary. Therefore, it is arbitrary.
Whimsical and
based on women fancy. And
yes,
that is
my
right. That is the
that is precisely the point, my lord.
The burden of
so, my lords, therefore. Grateful for the question, my lords. Because, my lords, the Constitution gives them discretion. They could have devised a consumer price index of their own. They could have gone to Purulia, 24 Parganas, Kolkata, and devised a consumer price index of their own. They did not.
Point well taken.
My lords, while I was just making the point that we've all been working very hard in the last 2 days. And the reason, my lords, is that the argument came up for the first time.
We have no doubt about whether you would have put in the matter. We have no doubt, I'm saying.
So
we have saying we have no doubt.
But my lords, the argument came up for the first time that it is a static figure. It has come after 20 years, after 6 courts and tribunals have held in my favor. Every time we won, a review was filed. We would win the review, then they would go up, then they would go down, then we would, and every single time, my lords, we succeeded. I won't repeat what has come before me, which is in terms of the arguments that were made in the courts below. Not once did they say that this AICPI figure is static. They said it's an ad hoc basis.
Taken here for the first time.
Yes, ma'am. Yes. And my lords, it's a factual argument. It's not a legal argument. My lords, if I may now come to the fact that
anything which you wish to add to what has already been submitted.
Yes, my lords, I'm not going to repeat. My lords will appreciate that the Royappa judgment is a guard against arbitrariness.
Yes. How would Royappa apply?
My lords, because it's a guard against arbitrariness in public employment.
The set of contention of yours, it's arbitrary, then goes without saying, it will apply.
Yes. My lords, if I may come to the fact that the employees of the West Bengal State Electricity Transmission Commission are getting a rate that is equivalent to the central government. Now, if I may come to, this is paper book 35 of
in fact, this plea was taken before CAT.
Yes, my lords.
It was taken.
But I would like to refresh our collective memory on it, my lords. Reason being that there is also a decision of this court, and that judgment has attained finality.
Yeah.
So, my Lord Justice Mishra had said that there are different categories of employees that are getting different rates. So, we had 3 categories so far. We had the employees at Bengal
and Bengal.
And West Bengal. But there is a further subcategory in West Bengal. So, first, if I may come to, this is paper book 35 of my counter, my lord.
Yes.
Respondent number 2.
Yes.
This is where it begins. And so they examined whether power companies could depart from the mandate to pay dearness allowance as central government rates on the grounds of financial hardship. My lords have the Supreme Court order, I think.
Yes.
So we can go to that first, my lord. Says in the facts and circumstances of the case, and more particularly, considering the fact that even till January 2016,
yes,
respective employees were paid the Dearness allowance at the central government rates. Has it been allowed or notice installation? My lords, I am told that notice has been issued on a review, but we also have a number of judgments after Sabrimala, which is also in review, that this can be relied on.
Well, you see, if it is a matter of view, it is not.
Fair enough. But currently,
yes.
But my lords, currently, as we speak,
yes,
there are now admittedly, four categories. And they are all, three are getting paid at the AICPI rate.
Yes.
I, for no good reason and no explicable reason, am getting paid at the rate that they decide whimsically from time to time,
yes,
with no basis, no material on record, and it then flies in the face of the government, the judgments of this court from time to time.
Yes.
My lords, I also wanted to place the fact that my lords have never hesitated to bring reasonableness into a government scheme that has been arbitrary in this regard.
No, but can we legislate what our query to you? You say that it has to be, we have to bring in reasonableness.
My lords, if I may point out what, my lords, this would not be akin to legislation. The reason being that due to the fact that the rules require a schema to be placed within the rules, and the rules do have a schema according to us, that anything concomitant to that, to give effect to that statute, is something that my lords will do, and that is the intention that will be read in.
Well,
and my lords, the intention may be read in from the fact that that particular rule is close to identical to the central rule.
So, which is this citation?
So this citation, my lords, is this is Kamani Metals versus Workmen.
Money was there in the file.
My lords, the book actually has a slightly different version, which is why we've given it to the Madam Court Master.
Oh, really? Give us the citation.
1967, true SCR. My lords, the electronic version is a little bit different. 1967.
Kamani, not pointed out that you were given it, but she says that it's a different version. Very different.
So Kamani is referred in this Bengal chemical.
Yes. It's referred in Bengal chemical, but I want to point out
Bengal chemicals, it is referred.
It is absolutely, my lords. But my lords, I wanted to point out something slightly different, which is only in the
citations.
1967, volume 2 SCR, page number 463.
Yes.
At page 474.
Yes.
Now, my lords had said that there is a hesitation to legislate. That is absolutely not what we are seeking. What we are saying is that they have already legislated. And what we are seeking is that my lords give effect to that. So what they did in Kamani, my lords, is, do my lords have it?
Yes. No, because you invoke the principle of reasonableness.
Of reasonableness.
Can we legislate or not? It is only in that background.
No, my lords, I am invoking Article 14 reason.
Please. Okay.
And non-arbitrariness.
Okay.
So, my lords, page 474.
Yes.
It says this brings us to the last question, which is related to the Dearness allowance payable to the monthly rated workmen. Previous to the present award, and this is the award by the Tribunal, The dearness allowance was payable in this company in the following manner. So then they put out the slabs on the first ₹100 up to ₹100, and this is the full salary. They say 60% with the minimum of the DA paid to the textile operatives by the Bombay Mill Owners Association. And then they put out various slabs up to ₹200, 300, 400, 500. This is what they had previously. The above percentage of dearness allowance is applicable when the Bombay cost of living index rests between 311 to 320. Variation in the above percentage to be allowed for 10-point movement in the index. First slab, 3% of dearness allowance, second slab so-and-so, fourth slab, third, fourth slab so-and-so. In the award, this has been altered to a scheme which is as follows. On the first ₹100, they change it to basic pay. My lords change it to basic pay instead of being the full salary. And then it is said that this is 60% on the second ₹100 basic pay up to 35%, etc. So this is the alteration that is done by my lords in Kamani. In Bengal Chemicals, my lords have also made clear that a sliding scale is to be read in when it's not there. That one can't just say that this fixed amount is to be given in terms of dearness allowance. That a sliding scale is then read in. My lords, I'll also hand over in my written submissions that I will amend based on what my lords have asked. A judgment in Ajay Kumar Das, where they say that memoranda can never override a regulation. And similarly, my lords, that is at, I'll give the citation.
Yes.
Similarly, my lords, in Ashok Ram versus the state of Maharashtra.
Yes.
My lords, in the Bank of Baroda versus G. Palani, 2020-25 has 6.1. Vested rights of employees were protected, and it was the supplanting of established legal frameworks with arbitrary governmental decisions was resisted. If I may read this, Lord, I'll also put it in a note. The Honorable Court's judgment citing with approval the precedent set in K. Swami. My lords, another 5-6 minutes.
Then we can finish today.
Yes, sir.
I'll take you wanted 3 minutes today.
We can finish.
No, wait, no. So we wish we can continue tomorrow.
I'll be grateful, my lords. Tomorrow I won't take more than 10 minutes.
Tomorrow also 5-6 minutes.
Okay.
I'll take 3 after that.
Fair enough.
I'll take 3 just to sum up, nothing.
We told you
after the leaves.
What we do is that can we do one thing? Can we just return your compilation?
Yes.
So that tomorrow give us a comprehensive.
Will.
What's it? Yes.
The compilation is.
एक folder में डाल के
Tomorrow we expect in the morning session this to be over. We request because we are just now informed that no, they would take about another 10 minutes. So this side another 10 more minutes.
Not more than 10.
Both of you. And then we expect.
Yes.
Because we have, at 1 o'clock, 2 o'clock, we have another.
No, we are at your lodge. This course.
Another bench.
We will be at your lodge.
Thank you.
Grateful. So grateful.
Lordship, in item 15, I represent the respondent. We kindly request that the matter be listed tomorrow or on a date in the next week.
Online answer किया था 15 number after notice में. First वो after notice आना तो उसमें time की
Yeah.
Right.
Yes.